Sound. Yes.
Lordship, I'm praying for your Lordship's very kind leave to move an urgent writ petition, your Lordship. What has happened, your Lordship? The rakes of the petitioner has reached the Pashkura railway yard, your Lordship. Now there's some anti-socials under the guidance of Anisur Rahman is not allowing to take down the articles which are there in the wagons, your Lordship. There are 21 wagons which are lying there. I'm recurring the penalty charges from 8th of April. I have accordingly mailed to the police station of Pashkura. I have
Already 16 it will take it up. 16.
Lordship, I'm recurring the
16.
Lordship, kindly hears. I'm recurring the penalty charges hourly basis. Lordship, kindly takes it up today.
For 8 you are doing that. On 16, I don't.
On 8, Lordship kindly appreciates. On 8, I have made the complaint. I was called on the 9th morning. I have approached the police station when nothing is being done. I have also
heard you on next working day tomorrow, if it is not possible. On the next possible.
To be taken up tomorrow morning, your Lordship, and kindly allows me to.
The other litigants to be attended, sir, madam.
I'm recording the damages on an hourly basis.
I have heard you no use of repetition 16th if you are ready, otherwise mention before the changes.
Lordship kindly takes it up tomorrow or day after.
Lordship, day after, how I will take up? Tell me. All are the holidays in between.
Lordship kindly appreciates that the only difficulty is that, your Lordship, the entire rake is stuck there, your Lordship. Lordship kindly allows me.
16th, I've said. Next working day, possible working day. Yes, next.
I'm praying
next, for this. Please, you have enough, madam. Next.
May
I have your Lordship's kindly, I had mentioned this matter yesterday. This pertains to one of the rally of Hanuman Jayanti where
today after there is a fixed matter at 3 p.m. Thereafter, supplementary list will be published. Leave is granted. All Hanuman Jayanti matters give it to the court officer.
But today it will be taken up today.
Today supplementary list will be published.
But after 3
after the 3 p.m. fixed matter hearing is over.
Yes, I'm deeply obliged. I'm deeply obliged.
Lordship, with your Lordship's permission, Lordship, I had mentioned this matter on Friday, citing the urgency that your Lordship had directed to approach the police station for protection. However, the police did not grant me protection. I'm a Maharaj. Lordship, after that, I was assaulted, my hands were cut, and I was hospitalized. Now, your Lordship, I've started receiving death threats. Random people have started.
Where is your matter? Filed?
Yes, your Lordship, it is filed. Your Lordship had directed to appear yesterday. However, yesterday the matter could not be taken up. Lordship, it's running as item number 217.
Tomorrow. New motion. Tomorrow.
Otherwise,
tomorrow. Next. Tomorrow is Friday.
Time, your Lordship.
No, the time I cannot say today. Tomorrow. Next.
Item number 1326 of monthly list for order. Very urgent matter.
Upgradation has been already taken up on a fixed date. Next date when upgradation will be taken up, you do that. Regularly you cannot come. You follow the list. Next. Use the microphone.
I had mentioned this matter, my lord. Your Lordship had asked me to come back post filing this writ petition, my lord. 16-year-old girl was kidnapped and still not recovered, my lord. I have the writ petition number, my lord, today.
Give it tomorrow. Leave tomorrow. Next.
Your Lordship leaves to file a matter on an urgent basis, my lord. 12th April, a small street corner meeting will take place, but till date, no refusal has been given by the police. Formal refusal, my lord. But kindly takes it up tomorrow.
Tomorrow. Give it. Tomorrow.
My lord, petitioner's shop room has been ransacked by some of the anti-socials of the locality, my lord. Repeated complaints have been made, but no steps have been taken.
Have you filed?
It has been filed, my lord. Item number.
Let it come. These are regular problems. Cannot be taken
up tomorrow, my lord.
No. Regular problems. Yes, next.
I'm praying for leave to move this application, my lord.
Use microphone.
I'm praying for leave to pray for your Lordship to move this application on 17th, my lord. The case is that on 4th of April, your Lordship taken up a similar application, but the petitioner company and one of his authorized representative came up before Lordship.
So have you filed that?
But I'm seeking leave to move this on 17th, my lord. Let it be fixed on 17th, my lord. 17th, my lord. I will serve in the meantime and come back.
All right. If you are absent, it will be dismissed. I'm telling you. On 17th. Leave 17th. Leave 17th. So list down.
Item number 1.
My lord, I am instructed to appear on behalf of the petitioner, my lord. It's an old matter, but I have
Yes.
the matter is otherwise ready for hearing.
Who is your other side?
No other side is appearing in the last occasion also.
When are you both of you ready for hearing? Tell me, fix a date with consent. Fix a date, both of you.
But any day after 2 weeks, my lord. My lord, since it's a change brief, I need to, my lord, take the briefs and all the papers from my client. My lord, any day after 2 weeks, subject to my learned friends, my lord, confirmation.
29th of April.
29th of April. I'm deeply obliged, lord.
Learned advocate for the petitioner and the state is present. Exchange of affidavits complete.
Yes, my lord. So far as I have ascertained from the earlier orders, if you lordship kindly see the earlier orders, lordship. Lord, order dated 11th of July 2022, my lord. Here, your
His
lordship will
every reply is taken on yes. Ki bola, present exchange of affidavits are complete. Let the writ petition be fixed for hearing on 29th of April 2025 with consent of the petition learned advocate appearing for the petitioner and for the state.
grateful, lordship.
Consent. Hearing.
Order number 2.
I'm for the state lordship
Yes.
released.
The records of the case reflect that Honorable Justice is Shobhushaji Bhattacharya
7th February
as marked on 7th of February 2020 marked the writ petition as heard in part. Accordingly, the writ petition is released from the list. Accordingly, let the matter go out of list. Accordingly, let the matter go out of list. Petitioner would be at liberty to mention before the court having determination.
Grateful lordship.
Next.
Order number 3.
With regard to the compromise.
I have the instruction to appear on behalf of the state. My lord, I am filing a report. My lord, peruse that report.
Report again. You have a statement over there.
But no, I have given a gist of the case and the subsequent statement regarding.
Subsequent, what do
the
the subsequent statement read?
I can send that.
You don't have a copy of the report.
I have a copy of the report, but there, my lord, I have not mentioned regarding the. I have mentioned the gist of that statement, my lord. My lord, peruse that. The last 2 pages, my lord. No, কোথায় রেকর্ডটা statement.
So your 161 statement states that they have entered into a compromised amicable settlement.
My lord.
Huh?
My lord.
So any other case is there against the accused persons?
No, my lord.
No other case. No other case.
অনেক বড় রিপোর্ট আছে দেখে।
But the de facto complaint was appearing for the trust.
Yes.
Huh?
My lord. Yes.
But I will get number 4. And do not stand in the way.
Yes, Mr. Nomni, any public element involved?
The private trust. Public money. No public money.
It's between two companies, my lord. I have given a detailed report regarding that. My lord can peruse my report and keep this matter tomorrow under to be mentioned, my lord.
Tomorrow, no time. So tomorrow again 3:30 you have called, sir.
What's
The first dismissal of because my application is also pending. My joint compromise application is also pending. The camp one is fine. Fine, is ours.
করে দিন। Status report submitted by the CID West Bengal, we kept with the record. At the end of the status report, it has been stated that the de facto complainant, namely Amrik Singh, was interrogated and his statement was recorded under section 161 of CRPC, as well as the same was videographed. In course of interrogation, the de facto complainant stated that he has entered into an amicable settlement in respect of the monetary dispute and is prepared for termination and settlement agreement, which was previously submitted before the High Court. Full stop. It has also been recorded at present, Amrik Singh, the de facto complainant, has no further allegation against the FIR named accused persons. In view of the joint compromise petition, is a joint compromise petition filed by the petitioner and the private respondent, and the nature of the allegations complaint of stems out from private dispute, particularly monetary transactions, and no element of public policy is violated in respect with regard to the criminal case for which investigation is being carried out by the CID West Bengal. I am of the view that in consonance with the settled propositions of law, further continuation of the proceedings are unwarranted. Accordingly, Boronabur PS case number 258/2024, dated 25/6/2024, under section 406, 420, 465, 467, 471, 120B of the Indian Penal Code is hereby quashed. Accordingly, CAN 1 of 2025 is allowed. WPA is disposed of, thus WPA is disposed of. Report submitted, we kept with the record. Next.
What about 4?
3 সময়।
What about 5?
That is number 5. I'm appealing for the
What
rest.
about 5?
Yes.
I'll let a copy of the same may kindly be handed over.
My lord,
How many cases?
my lord, at least, my lord, 2 cases has been filed, my lord. There was clear violation of your lordship's order, my lord. They used 2-wheelers, 4-wheelers, my lord. Instead of 500, the participant was, my lord, were 5,000.
My lord,
My report.
my lord, this is an allegation by way of report, I believe. So, my lord, we have a copy and I have to face it before your lordships.
You have a criminal case. Go and face the criminal cases.
My lord, criminal case is one part. Participation instead of 5,000, instead of 500, 5,000. That's not the matter. We have to chase the report, your lordships. Somebody is using a report. Let us see it. Now your lordships find. Now I have to today, your lordships. Now that was the crowded road. Inconvenience to the public. What has happened today, your lordships, in Calcutta city and Howrah city? Inconvenience is not caused, my lord, to us. You are giving permission. And for our permission, we have to approach the court.
Anyway, I don't want to go into that.
Absolutely. They have the power, they can lodge the cases, they can file the cases. Now have to deal with. Now, may I take a point, Your Lordship? May I take a point? Your Lordships, it is the returnable day before Your Lordships.
Yes.
Your Lordship wanted report. Before filing a report and informing Your Lordship, how could they file a court case? In FIR, they ought to have taken a permission from Your Lordship that, look, this gentleman has done this in violation of the court's order.
That's against the organizers, they will be doing, sir, if you are violating.
No, that's another aspect, Your Lordship. But they ought to have first informed Your Lordship.
This is, my lord, at least
they ought to have
the provision.
I have not.
All participants' name were given. All name of the participants were given. 500 participants' name were given.
Yes, whatever participants we have, and that we have to do by way of affidavit with Aadhaar card. Now, Your Lordship, take an example.
Report down. No.
Either are the participants by whose names have been given to them or not. But that's the point to be. But every year we are facing this. It's not valid for this year. Somebody can do anything, and somebody cannot do anything. If that be the law, my lord, we are out of court. If that be the law, we are out of court. We have seen also how many people coming through the others. No, you are going to that extent. That's why I'm bound. I'm forced to do this.
Your Lordship, my lord, which then, my lord, I
We
can
have
file
given your.
No, you tell me one thing. 500 participants' name were submitted before you.
Yes, my lord, 303. We didn't have 500.
My lord, they
We have
provided
303 with Aadhaar card file number.
name of the participant. Instead of that,
My lord, maximum was 500. We could not. We have not given back out of anyone, out of 303. So your losses kindly take it on record. Let us, my lord, have their report. Whatever we have submitted to them, we will file an affidavit. You have to look into this at least. Somebody will come up the state and file a report. That's not end of the matter, your losses.
And how many criminal cases registered?
We have miking, we have microphone, we have your losses totally by your handbill. Who are the participants? How many
police cases has been initiated?
Everything.
At where? One Shibpur, one Howrah.
This is your lordship, some Shibpur.
Yes, my lord. Shibpur police station.
Both
One
the cases.
police station, another is Howrah police station, case number 154, my lord, under section 223, my lord.
That's what they have filed. According to me, my lord, they ought to have taken the permission from the house.
My lord, for lodging a criminal, my lord, FIR, I need your lordship permission. Which provision, my lord, entitled them to make this type of submission, my lord?
This is propriety. Court wanted a report from the state.
My lord, 300, they are providing us 300 numbers of participants. 5,000 participants, my lord, they are in the rally. I have, my lord, photographs also, my lord. Your lordship was pleased to allow, my lord, one vehicle, one four-wheeler.
Two 23 is a police Is the police empowered to register? Madam, is 223 police empowered to register? Alright, you come tomorrow, satisfy the court whether under 223 police can register a case. You have other offences, I have got nothing to say because this is an evidence disobedience to order duly promulgated by public servant. That is to be done by the court concerned if there has been a violation, or your DC did, or the person de facto complaint was a public servant who had passed any order. You come prepared tomorrow.
My lord,
Come prepared tomorrow.
let me have a copy of the report so that
Tomorrow I'll give the report whether let them satisfy regarding the sustainability of the case.
they are alleging violation. So let us face it. I am facing it. Let me face it.
All right. Tomorrow, if I give it to you, it will be for filing exception and all those things. So wait for that tomorrow. Let them make their submission. I'll allow you.
All right. All right.
Can't hear you, Mr. Take the microphone.
Yesterday, your lordship has been pleased to, Lord, dispose of the matter, and since the FIR has been registered, let the investigation go on. Your lordship has passed the order.
That's in that matter.
Anjani Putra.
So over
Same
here,
order that is a violation.
over here, they have taken up an objection.
You can defend in the proceeding.
I am facing it.
No,
here.
you can defend. You cannot defend here.
Yeah, I can.
Yes, unless you challenge that.
All right, you answer that. Come
that.
tomorrow. Come tomorrow. Don't waste time in the morning.
Yes.
Come tomorrow. 223. Whether the de facto complainant who lodged the case, whether he had passed any order or not.
Who blood?
223 proceedings you have drawn up under the BNS. This just whether the de facto complainant, because these are proceedings to be done by the person who passed the order. You know that 197 that 195 bar is there. You understand that earlier one. The same provisions are over here also. You just check up over here whether the de facto complainant who registered the case, he passed any order or not, or is it only for High Court's violation? Come tomorrow, or tomorrow I'm 16th I'm keeping the matter.
16th, Lord, I have some problem.
16, 17, then you
come after this. Now that urgency is not there, sir, come after this.
22nd or
21st. Release the petition on 21st of April 2025. Another same heading report submitted by the state. We kept with the record. Next. Start.
6. Order number 6.
I'm for the state in this matter. May I file my affidavit of service? Lordship, writ petition is the classic instance of tolerable exercise of power on the part of the Regent Park Police Station. Lordship, if your Lordship kindly come to my first election, which would appear at page number 14. Lordship, there is a section 17 application. I have obtained an order of status. Status. If your Lordship kindly come to page number 14, last paragraph. The counsel for both sides are directed to complete their pleadings. In the meantime, status quo be maintained till the next date. Lordship, kindly, this is the order dated 28th of February 2025. The order is valid till 30th of April. Lordship, in the meantime, on 27th of March 2025.
Where is the next order? 30th of April?
30th of April has not yet come.
No, where is that order? This is up to 28th of February.
Yes, order was passed on 28th of February. I am enjoying the interim order till 30th of April. In the meantime, on 27th of March, my client has been forcibly evicted from the flat in question. At that material time, my minor son, who is the intending candidate for this year's West Bengal Joint Entrance Examination and NEET examination, he has been forcefully evicted, and no copy of inventory and panchnama was filed, was supplied to me, has been passed by coordinate bench of this Honorable High Court. Page number 20. This particular order, the coordinate bench of this Honorable High Court has been pleased to direct.
But have you brought it to the notice of the tribunal?
No, Lordship, tribunal is not working.
Lordship, Your Lordship, I appear on behalf of the respondent number 4. Your
Yes.
Lordship, an essay has been filed by them before the DRT, which is already pending, Your Lordship. This writ is not maintainable, and the police was only required to assist the and the status quo was granted on the basis of a settlement, Your Lordship, which failed. Your
So
Lordship,
that means
I
you
had the
cannot
copy
take
of the settlement agreement.
so you obtain an order from the concerned tribunal before effecting the order. The matter was before the tribunal.
We had intimated them by a letter dated 6 1 minute.
My lord, I am for the state in this matter, my lord. The police has nothing to play, no role to play here, my lord, because it was the court bailiff who has given possession, and police was there only to see the law and order problem. By pursuant to the order of the court, my lord, under section 14, my lord, the order was passed, and this authorized officer was handed over possession by the court bailiff.
Lordship,
Police did nothing, and allegation against police I fail to understand.
Lordship, kindly come to page number 18 of the writ petition. Kindly come to.
How you are bank finance company, madam? How can you submit this? Your pleadings were not complete. Over here, there is a direction for completion of pleadings, and 30th April date was fixed. See the last part of the order.
Yes, Your Lordship. Your Lordship, we had intimated them by a letter dated 6th March. Your Lordship, if the DRT is in the system of the matter, Your Lordship, they can't come here while already availing the going.
They can't. You will throw them out. They will not come. You are throwing them out despite a tribunal order. They will not come to High Court. You satisfy me that in spite you could have obtained permission from the DRT 30th. Prior to that, you are executing some order. I don't understand.
Lordship, kindly come to page number 18 of the writ petition, my annexure to the concerned superintendent of police. Everything has been made crystal clear.
Without having put in bearing. Which finance company is this?
Protean Finance.
Protean Finance.
My learned friend is representing the company.
NBFC, Your Lordship. Private NBFC.
Lordship, kindly allow me to rely on a judgment which is appearing at annexure P3, page number 20. Kindly allow me to place. The petitioner before this court on respondent number 7. Kindly come to page number 20, annexure P3.
Wait, sir. Your matter has been updated. Thereafter, you are showing as if you are the only person. You are not paying the money, creating problems. Yes, state. What order? Where from did you get the instruction to take? Did they deposit the cost? Did they deposit the cost?
My lord, the police cost was deposited, my lord, as per instruction.
Where is it in the report?
My lord, the last portion of the first page, my lord, prior to the execution, the court bailiff submitted requisition for police assistance as police cost paid, and accordingly police assistance was rendered as per police cost paid.
Who is the court bailiff over here under surface?
Court bailiff, the ACJM, it is before the ACJM, my lord, as per section 14. The bailiff has gone there, bailiff has given possession. Police was standing there to see law and order. There's no problem takes place.
Lordship, can you appreciate one aspect? Status
We
quo
don't
has
have
been
anything. If
enforced.
your lordship says, my lord, we will do.
Did you communicate with the ACJM?
Yes, this report was filed later on.
No. Petitioner informed the ACJM.
Petitioner.
Lordship, there is no occasion for the petitioner to inform the with regard to the proceedings initiated by the finance company.
When was this order passed by the ACJM?
Not my knowledge, Lordship.
11th of February order, I believe.
That was not communicated to us, to the petitioner.
Madam, 11th of February order.
They are aware of the order, your lordship. They are before the DRT. They are aware of the order. The possession order was passed long back. They have come before the DRT after that, your lordship.
Lordship, even
So if it is that the order was after that order, why did you go for execution of that order? 11th of February order was passed by the ACJM. Till that time you did not take possession. 28th of February an order is passed by the DRT for maintaining status quo.
Yes, your lordship, it was passed on the basis of a settlement process. The settlement failed, your lordship.
Where is that written over here? Where is that settlement written over here?
Your lordship, it's written in the order, your lordship.
So there is no default clause mentioned over here.
Your lordship, in the third paragraph, learned counsel for the essay applicant submits that settlement process in the matter is going on and prays for, and thereafter the status quo, thereafter the order for the status quo was.
So after both the sides are directed to complete their pleadings in the meantime. So you should have taken a direction from the DRT 3.
Your lordship kindly allows me to come tomorrow with complete instructions. Your lordship, this matter has they had mentioned the matter without giving a notice upon us. Your lordship kindly allows me to come back
Lordship,
tomorrow.
I have intimated them twice. Kindly come to affidavit service. I have intimated to them on 7th on
Your lordship,
8th.
I had received.
Come back. Come back on
Grateful.
Wednesday. Come back on Wednesday.
Grateful, lordship. I shall.
Report submitted by the state, we kept with the record. Learned advocate 8 appearing for the respondent number 4, 6 for accommodation, 6 for some time. Learned advocate for the petitioner is present and is aggrieved by the act and actions of the state respondents as well as the private respondents, be that as it may. The same will be considered on 16th of April 2025, when the writ petition will appear under the same heading as an accommodation has been paid for on behalf of the private respondent.
In item number 7, Millet, I'm appearing for the Millet respondent number 2 to 4, Millet. Millet.
Lordship, I am appearing for the state respondent in this matter, Lordship.
Yes, have you registered a case? What are disconnected?
My water connection is restored, Lordship. In the presence of the petitioner, a petitioner also written a letter to the officer in charge stating his water supply is restored, Lordship.
Yes, what is the grievance, further grievance?
Millet, on the last occasion, Millet, that is on Friday, Millet, I mentioned you before your lordship, Millet.
You are the respondent, let the petitioner speak. Yes.
My lord, when the water connection has been reconnected, my lord, I have no further grievance.
Lordship, report is with me. I am placing the
yes. Report submitted on report submitted by on behalf of the state. We kept with the record. Learned advocate 8 appearing for the petitioner submits that water connection has been restored. As such, he has no complaint investigate of the inaction in relation to the communications made to the local police authorities. Learned advocate for the private respondent submits that the police authority is have threatened them. Full stop. If there are inconveniences faced by the private respondent, they will communicate with the gist of with the necessary grievances before the higher police officials concerned. Further pendency of the writ petition is unwarranted. So, accordingly, EWPA.
One intelligence that I beg to make, Millard, I have lodged a complaint, Millard, addressing Millard the higher officials as well, with regard to their high-handed.
That is not before the recording, Lordship.
Accordingly, WPA 26022 of 2024 is disposed of. Reports to submitted লেখা আছে না সার্ভার কপিস করুন
Eight.
I appear on behalf of respondent number 9 and 10, Milord.
This was the petitioner.
Milord, I don't think anyone is appearing.
Who mentioned the matter?
Milord, we have taken out 2 applications, Milord.
No,
One
who
is
mentioned the matter? For upgradation? Who mentioned the matter for upgradation?
the mentioning slip can.
Lordship was pleased to file a report, my lord, in this matter.
No, there is no direction over here in this matter. They are wanting police picket only. That direction.
We have
since the writ petition is not pursued by the petitioner. No petitioner is present.
We have brought the report. Not if your lordship kindly consider the report. But everything is under control and police picket, RFS, RSF, everyone is there.
Mr. Banerjee, difficulty is that I could have, but I don't know at whose instance the matter has come because I only record the number. In upgradation, I only record the number. It is very difficult if the members of the bar, after mentioning, are not upgrading the matter, not appearing. I'm dismissing it for default, sir, only, nothing else.
The report be kept on.
My lord can dismiss the writ petition for default. My lord, one humble request, my lord. We have taken out one application for perjury.
That is it.
My lord, kindly keep that alive, my lord, and fix it any date convenient to your lordship, my lord.
How
Because
can I, sir?
all statements have been made in the writ petition, my lord.
If the writ petition is dismissed, how the application survive?
Lord, it's a perjury application, my lord. Or your lordship can take up the writ petition, my lord, along with my lord the perjury.
How can in absence? These are becoming burden for me. Second time, third time taking up the matters.
Because they have nothing to say now. Because at this stage, my lord, everything is under control. Your lordship will see from the photographs also. I have annexed there.
Give the report. I'm dismissing it for default, sir. Since the petition is not pursued by the petitioner and Mr. Banerjee, learned advocate appearing for the state, submits a report stating that the situation is completely under control.
As it appears from the photographs also.
Report I've seen. You have a respondent number, Mr. Chatterjee?
Number 9 and 10.
এটা কি ধরনের সেন্টেন্স?
Since the resolution is not pursued by the petitioner and Mr. Banerjee and the advocate acting for the state submits a report stating that the situation is completely under control.
The prayers so advanced by the petitioner at the stage do not appear to be in consonance with the state of affairs existing. Full stop. Learned advocate for the respondent number 9 and 10 is present. However, since the petitioner is not represented, let the writ petition being WPA 26239 of 2024 be dismissed for default. Reports are submitted, be kept with the record. Report of the
Let it be dismissed.
Dismiss for default. No, no. I can't do anything because I don't keep a track whether they have mentioned, who has mentioned.
Their grievance has been fulfilled, my lord. No, nothing to say.
Can't do that, sir. Can't do that. I have not done it in case of anybody. That we know that.
Can one one more line be recorded? My lord, that we have denied the allegations made in the writ petition, my lord.
Dismiss for default. How can I do that, sir? They will come up if it's considered on merit.
Very well. Deep blue.
Next.
Item number 9.
Lord, I beg to appear on behalf of the state respondents.
Item number 9.
Yes.
Search of the work, I went to Dubai.
After I came back, suddenly a group of people started to abuse me by saying that I have stolen some property, including gold from Dubai. These people have abused me and my family members, and after that, my lord, one civic volunteers came, Toton Mondol came, and he said that if you want to settle the issue, come and meet me personally. Now, lordship, this
226 ki like korbe.
No,
why are you wanting to invoking 226?
I have made a complaint, lodged a complaint before the police station, which is in 33.
So what cognizable offense is made out?
Yes, the question is, my lord, the civic volunteer who is not a police, who is interfering in this issue, where there is no FIR against me at anywhere. Police is not doing anything. Civic volunteer. No, Lord, you kindly come to the FIR. Why this is why cognizable offense?
What happened in this matter, my lord?
You go under 175(3) before the local magistrate.
What happened in one paragraph,
I have seen there is no substance. Let the magistrate conduct an inquiry.
No, we have taken steps.
And thereafter pass necessary orders.
Kindly bears with me. Kindly bears with me. Lord, what happened in this matter? Lord, the writ petitioner worked in a jewelry shop at Dubai. He thieved 350 gram golds from there. He came back to Kolkata. The person who arranged him the work there, he is a relative of the private respondent. He intimated the private respondent whether he is back in his hometown or not. The private respondent went to his house and asked him to return this gold. And since there is a complaint with regard to the that civic volunteer came to his house and threatened him, we have conducted an inquiry. And 126 stroke 135.
126 you conduct an inquiry for this, sir.
No,
after allegations are theft.
After
register a criminal case and do that.
No, relating to his conduct, man, kindly listen to me. Relating to his conduct, we have already made a prayer for his demobilization. We have already made it to the superior authorities against that civic volunteer. We have already
kindly record it and kindly
yes.
Report submitted aid by the state be kept with the record. Learned advocate appearing in for the petitioner submit aids that the petitioner was threatened by a civic volunteer who is the respondent number.
Civic volunteer 5.
Who is the respondent number 5?
There has been
to the extent that the petitioner has committed a theft of gold jewelry from Dubai.
Yes.
Learned advocate appearing for the petitioner further submits that since the petitioner happens to be a civic volunteer, he has been in misutilizing his position as a police and threatening the petitioner without any foundation or basis is in law, as there is no criminal case pending against the petitioner. Full stop. Petitioner also feels afraid as the respondent number 5 happens to be associated with the police department. Full stop. Learned advocate for the state submits that state has recommended aid for steps being taken against the civic volunteer concerned. Proceedings have been drawn up under section 126 135 BNSS. Next paragraph. I have considered the submissions of the petitioner as well as the report submitted by the state. It would have been fit and proper for the state to register a case and thereafter start any inquiry or investigation. That the same not being done at the relevant point of time. The accusations of the petitioner on the face of it cannot be thrown away. Accordingly, petitioner would be at liberty to approach the jurisdictional court under section 175(3) of the BNSS. Learned magistrate would call for a report for ascertaining whether any cognizable offense is made out. Thereafter, also assess whether a case for investigation has been made out, and then exercise his discretion in accordance with law. Sure. With the aforesaid observations,
that there is a prayer made by the state for demobilizing
Already
this.
been recorded.
That has already been recorded.
that I've said already.
Already.
With the aforesaid observations, WPA number 26493 of 2020.
Since allegation of threatening, Miller, we have taken all
Let's
this is submitted prosecution, Miller. And
report
the resolution of
reports submitted locally. Reports submitted. We kept it.
The petitioner father submitted, since the petitioner happens to be a civic volunteer, petitioner.
A respondent number 5 happens to be a citizen.
Item number 10. Well, I am for the petitioner. Lordship, kindly come to page number 74. There is an order of injunction. There is no implementation of this order. I sought the police's intervention for the implementation of the order. Interim order by the civil court. My lord, kindly come to 74. My representation. Lordship, kindly come to the relevant portion in 75. Paragraph number 3, that the learned court of civil judge junior division Amta Howrah in its order dated such and such upon accepting the application filed under order 39 rule 1 and 2 CPC such and such, the application for the ad interim injunction filed by the plaintiff is allowed. The defendant number 1 is hereby restrained from disturbing the peaceful possession of the plaintiff. So it's a property. The private respondents taking the aid
Where
of
is the direction upon the police authorities?
My lord, that direction for which I am before your lordship, my lord. That there is no application made for the police help for the concerned civil court. My lord, that is the
Petitioner is aggrieved by the fact that ad, in spite of direction passed by the learned aid civil judge junior division Amta Howrah in connection with what is your TS number?
Title suit number 78 of 2021, my lord.
In connection with title TS 78 of 2021, wherein the private respondents were restrained from disturbing the peaceful possession of the petitioner of the plaintiff in the suit.
They are also changing the nature and character of the
private respondents had been continuing their illegal objective of changing of interfering with the peaceful possession of the property, forcefully trying to enter the property of the petitioner, and are also also trying to grab the property and also trying to change the nature and character of the property. Full stop. When the petitioner resisted such illegal acts, he was subject to assault and abuse. Full stop. Information was furnished before the police authorities. However, in spite of informing the police authorities, no action has been taken.
My lord, there is no direction on me by the learned junior division court, my lord.
Learned advocate for the state opposite is the contentions and submits that whenever there has been crisis of law and order, the police authorities have taken steps in accordance with law. Inquiry was conducted by the police authorities. However, since the civil court is already in CC of the issue, without any specific directions from any court of law, the police authorities were reluctant to take any steps in a dispute which is civil in nature. So, having considered the submissions advanced by both the parties, I am of the view that the petitioner is to advise who would approach the civil court for the necessary directions upon the police authorities. In case such
My lord.
directions are passed, the police authority, in case such direction is passed upon the police authorities, they would respect, obey, and implement such order. Acha. Till such, in the meantime, police authorities would ensure that there is no breach of the peace and or tranquility and or any untoward incident resulting from the strained relationship between the parties. With the aforesaid observations, WPA 26494 of 2024 is
My lord,
disposed.
may I allow to submit the report?
Yes, the reports are submitted. We kept with the record.
Item number 11. State respondents.
Yes, sir. Use the microphone.
Cultivating the said land, lordship. It is not
Huh?
process, lordship. And cultivating the said land.
You are now cultivating or not? Cannot.
But absolutely civil dispute between the co-sharers, Milord, over the Milord possession of an immovable property. The allegation of threatening, Milord, we have taken steps, submitted the necessary prosecution.
Petitioner alleges that
Milord, may I file the report, Milord?
Yes, sir. His peaceful enjoyment of the property is being interfered with at the behest of the private respondent, and to the the private respondent has been creating disturbance. Respondents, the private respondents have been creating disturbance is for his cultivation with the intent of grabbing the property. Learned advocate for the state submits a report and contains the act that the nature of the dispute complained of is a long-standing land dispute between the petitioners and the private respondents. Police authority cannot interfere. Police authorities cannot interfere with the same until and unless there are specific directions from the court of law. Full stop. Be that as it may, since the petitioner has already complained, if there is any breach of the peace or tranquility, the police authorities would ensure that no untoward incident takes place because of the strained relationship existing between the parties. Shalom. With the aforesaid observations, WPA 26520 of 2024 is disposed of. Reports are submitted. We kept with the record. Several copies next.
I am kindly directed to hand over the copy of the report, lordship.
The copy of the report we handed over to learned advocate appearing for the petition. Next.
Item number 12.
Item number 12, I am appealing for the private respondent.
State respondents.
I am for the petition. My lord, senior citizen about 75 years. In the owner of a recorded total disputes of land. The private respondents covered are every day obstructing and creating disturbance.
Police did not act.
No, allegation of threatening and hurling abusive languages. We have necessary steps, submitted prosecutions under section 126 of BNSS.
Bas. See that.
May I file the report,
Mr. Mustafa, don't create marshmallow problem over there. You are enjoying the property?
But they are disturbed.
But the allegation is against the municipality. Can you see the representations?
May I get a copy of the report?
Petitioner is aggrieved by the fact that the private respondents are threatening him and hurling abuses for or evicting him from his lawful occupancy. Full stop. Learned advocate for the private respondent on the other hand submits that the main accusations are against state respondents, but unnecessarily the private respondents have been embroiled in the accusation so made. Be that as it may, state has submitted a report reflects that since the allegations are of threat and abuse, police authority is 126 done.
Lordship.
So police authority have taken steps by drawing up proceedings under section 126 oblique 135 of the BNSS. Having considered the nature of the dispute, I am of the opinion that there is no scope for interference with the police authorities except for keeping surveillance in respect of any breach of peace or tranquility taking place. Police authorities would additionally see that no untoward incident results because of the inimical relationship existing between the parties. With the aforesaid observations, WPA 26547 of 2024 is disposed of. Reports are submitted, be kept in the record. Copy of the report be handed over to Mr. Mustafa.
May I get a copy of the report?
Mr. Mustafa, give it to him. Next.
I will petitioner.
Yes. Who is for the state?
I'm for the state, madam.
But the petitioner, my lord.
Yes, Mr. Shamanto.
My lord, initially, my lord, they lodged the complaint. A zero FIR has been initiated. It has been transferred to the Mathia, and there a FIR has been initiated. My lord, with respect to Mathia, I do not have the report because it falls with the Bosirat PD. Kindly direct me to bring the report. I will, my lord.
Achha. Let them produce the report, huh? Achha.
Petition. Zero and the new FIR.
Petitioner is aggrieved by the inaction of the police authorities. However, Mr. Shamanto, learned advocate appearing on behalf of the state, submits that on the basis of the information so lodged with Parashat police station, a zero FIR has been drawn up and sent to which police station?
Mathia.
Mathia police station. Learned advocate intends to produce the report of the Mathia police station. List the writ petition under the 17th. You are coming.
Yes, I will, my lord. Your lordship has fixed so many matters of mine. On 17th, I have to
be mentioned. 17th only, small matter only. Huh?
Yes.
Oh, you put the 17th in April 2000. Another heading to be mentioned.
14.
It to be mentioned. I have to
14, I don't know why it has come, my lord. It was heard before your lordship earlier. No notice was served upon us before mentioning.
I don't know this as who is appearing for the state.
Appearing for the state and led by me.
Who is appearing, leading you?
Mr. Shumon Ghosh.
Oh, I don't know what this is. Who has mentioned this matter? There is a exchange of evidence complete.
No, my lord. There was a direction for a CCTV footage report to be placed before your lordship. We were supposed to hand over a compilation of judgments and documents. My lord,
Who mentioned this matter? Who mentioned this matter?
We have not, my lord.
Let the matter go out of list for the present and be listed in the month list of July 2025 as none appears on behalf of the petitioner. Also, however, learned advocate for the private respondent number 7 and the state is present. Give your names. All right. July. Yeah,
15.
Yes, who is appearing? State, who have you served the state?
My lord, has been served, my lord. He's there with me, but may I inform him again, my lord? He has been informed after mentioning as well.
All right, but EO and AR was supposed to be filed. Nothing more can be done. Inform the state. All right. The main thrust of allegation in the repetition is in respect of the arrested accused being produced after 24 hours in violation of the constitutional provisions as well as the provisions of the CRPC of the BNSS. Full stop. Consider you are on bail right now.
I'm on bail.
Considering the issue to be decided, I am of the view that the same requires exchange of affidavits. Accordingly, the state respondents are directed to file their affidavit in opposition by time April. মে মাসে আছে by 10th of May করে দাও by 10th of May 2025 we affidavit is reply if any by the petitioner by এই করে দিন 22nd of May last date by 22nd of May 2025 release the writ petition under the heading hearing in the month list of June 2025.
For one more indulgence, the prayer is not there. But the CCTV footage of this Eco Park police station from 21st of April, 23rd of April. It will show that I was there.
Which year?
But 2024, my. The representation was made long if available, man. Only if available. They're supposed to keep it for 18 months.
Achha, in case the CCTV footage, in case the CCTV CCTV থাকবে কি footages are available in case the police authority would preserve the CCTV footages from 21st of
April 2024 to 23rd of April 2024. Of Eco Park police station.
Provided the same is available. In case the same is not available, police authority would incorporate the same by making by way of necessary instructions in the affidavit in opposition. Sure.
Hello, in this matter, my lord, Sambudhu Datta appearing for the state, my lord. He has not come to court, my lord, due to illness, my lord.
Not today, not today. Next day it will be taken up. Retaining the position. Not today,
17. For the petitioner. Malad, please.
I am for the private estate.
Malad, it
But
is
have you served the state for after upgradation?
Yes. Huh?
After upgradation, have you served the state?
The advocate on record, I need to take instructions.
Yes, it was appearing when they did not appear, so your lordship made it.
Last occasion, the state appeared.
The last occasion, yes, Devanshu Dinda. You did not appear. Where is he? Let it be not today. Last time petitioner did not appear. Not today.
The notice was served. The notice was served. I have a copy of the.
He appeared on the last occasion.
Yes.
Not today. Inform him. Next day I'll take up the matter. I'm keeping the matter. It's written in the list.
18.
18, I beg to appear for the private respondents, your lordship.
Who is for the petitioner?
Lordship.
Yes. Have you got a report?
Lordship, I have got a report, lordship.
So why are they unable to enter the house?
No.
No, the landlord advocate. You are for the petitioner.
I am for the private respondent.
I am for the petitioner.
Lordship, that is a civil dispute, lordship. The father gifted the property to his daughter, lordship, and but the father refused to not allowing her daughter to enter his house, lordship. That is the one order is passed by my Lord Justice Hanuman Bhattacharya, lordship. In that order, which my learned friend petitioner is suppressed, in that order, my Lord Justice Hanuman Bhattacharya stated, recorded the father states that the petitioner here did not make any attempt to meet him. It is up to the father and the daughter to decide whether they would maintain a relation with themselves, lordship. The writ petitioner cannot pass any order compelling the father to meet his daughter, lordship. He is claiming that no one allowing her to meet the father, but it's not true, lordship. This is purely a civil dispute. Father is not
Petitioner is saying, petitioner, yes. What do you have got to say? There was an earlier order by the High Court.
If I may, the petitioner hasn't made any submissions as of now.
My lord, Devobroto Mondal, my lord, he is my lord, recorded lawyer.
This matter has appeared on previous 2 occasions. None.
Mr. Yusuf, you have got a report.
Prior to that, if I may submit your lordship two
Oh,
things.
হয়ে গেছে petitioner
Your lordship, the father who has not been made a party in this writ petition in the earlier round of writ petition, the court has given the petitioner liberty to add him as a party. He appeared before the court virtually, personally, and refused to take any assistance from the daughter. Thereafter, the writ petition was disposed of. In this writ petition, the father has not been made a party, one. Secondly, what she has suppressed, the petitioner has suppressed, is that the father has already filed a suit in the court below challenging such guilties. All these facts, the previous writ petition, the orders passed, have been suppressed in this writ petition. The petitioner has...
Who are you? Who are you?
I am for the private respondents who happen to be the uncle of the petitioner. Uncle and other relatives of
The
the
nature
petitioner.
of the petitioner is agreeing that she is unable to enter the property as she obstructed aid by the private respondents. Reporter, private aid respondents. Learned advocate appearing for the state submit is that there has been suppression of facts. The suppression is to the extent aimed at earlier
Earlier order dated first at October 2024, Your Lordship, passed by my Lord Justice Hiranandani Bhattacharya.
earlier order asked by a coordinate in civil court or writ petition?
In writ petition, Your Lordship.
Achha. Earlier order passed by the coordinate bench reflects on the goes to show. The sentence support.
The suppression is to the extent that earlier order passed by a coordinate bench
has not been spelled out or enclosed in the writ petition. Very in its surface is that there is a dispute between the father of the present petitioner who had gifted the property in her favor. Full stop. It has also been pointed out by the private respondents that a civil suit is pending.
Suit is pending.
Civil suit is pending.
A civil suit is pending between the parties. Full stop. Since the civil court is already in the issue, the petitioner would approach the civil court for all necessary remedies. There is no scope for interference by this court. Accordingly, WPA 27459 of 2024 is disposed of. Reports are submitted. Be kept with the record. Give a copy of the report. Needless to state, as no affidavits have been called for from the respondents, the accusations and the allegations made in the writ petition are deemed not to have been admitted.
19.
Item 19, I appear for the state.
Yes.
Lord, there is a civil court order at page 15. Your Lordship, kindly see page 15, my Lord. That the instance should be and the same is decreed ex parte, that the plaintiff is the sole owner of the suit property, that the defendants...
My Lord, let my appearance be recorded, my Lord. I was...
Where?
In item number 18, my Lord, I am for the petitioner. Your Lordship has passed the order, my Lord.
Petitioner now, Sobusai Galaxy নামটা লিখতে।
My Lord.
19 years.
My Lord,
so you execute the decree, sir.
My Lord, the defendants and their men and agents are hereby restrained from disturbing the plaintiffs in their peaceful...
This is the decree. You have got to execute the decree.
Yes.
Where is your execution case?
My Lord, they are disturbing my possession, my Lord.
My Lord,
in spite of the civil court's order, my
yes,
Lord.
Madam. Yes, madam.
A general diary was formed, was registered. Thereafter, inquiry was made, and a case, Vaide Nadial PS case, has been initiated under section 223 and 3293 and 35 of the BNS.
Give the copy of the report, madam, to my officer.
My Lord.
Petitioner is aggrieved by the fact that in spite of a decree having been passed
Yes.
in connection with TS 1407 of the 2019 by the civil judge, junior division, third court, Alipur. The defendants, the private respondents are pursuing their illegal activity is for grabbing the property of the petitioner and are continuously disturbing and obstructing him. Full stop. To that effect, petitioner informed the police station, and in spite of informing the police station, no steps have been taken by the police authorities. Full stop. Learned advocate for the state has submitted a report and further drawn the attention of the court in respect of the steps taken by Nadia police station, including the factum of registration of a police station case for violation of the order of the civil court.
For trespass, my lord.
Understand? For trespassing into the property, having considered the nature of the dispute complained of and the steps taken by the police authorities, I am of the view that for issues relating to possession of the property, it would be the domain of the civil court, which has passed the decree to implement its order. Full stop. Police authority would only ensure that there is no breach of the peace of
Vigil is being
and or any untoward incident taking place because of the strained relationship existing between the parties. With the aforesaid observations, WPA number 27N462 of 24 is disposed of. Reports reports are submitted, be kept with the record. A copy of the report be handed over to the learned.
My lord, I don't have a copy. If my lord,
one copy you have.
I have only one copy, which I handed over to court.
A subsequent one copy.
Which I have handed to court, my lord. He can take it. Sure, even I don't have a copy.
My lord, may I take the copy and xerox and submit the court?
No, apply for certified copy from the department. If the petitioner applies for certified copy of the police report, the department end will make available such copy to the petitioner.
20.
একবার আরম্ভ করতে সবাইকে ডিস্টার্ব করে দেখে ফেলি।
Not the affidavit of service to be kept with the record.
Evidence service file be kept with the record. Next.
This is my application, my lord.
Yes.
Petition.
Who is for the state? Who is for the state? You.
I am for the
Banerjee. Yes.
My lord.
Have you done anything?
My lord, I have received the report. My lord.
And the case has been registered or no?
Yes, case has been registered.
After has been registered, my lord, already, my lord.
On 24th of the December.
PS case number 751 of 24, my lord.
Yes.
Dated 28/12/2024, my lord.
But no further steps has been taken, my lord.
All right, I am directing as superior officer to.
But is in progress, my lord.
Additional SP will monitor the investigation of the case. Nothing more than that. Petitioner is agreed by the fact that in spite of Dholahat PS case number 751/24 registered for investigation, but there has been no steps taken by the police authorities. I find that the accusations made in the writ petition in the information furnished to the police authorities include amongst others alleged offense is for forgery and preparation of fake deeds. Full stop. Learned advocate for the state submits that the investigation of the case is under progress and appropriate steps have been taken by the investigating officer of the case. Having considered that the case has been very recently, it has been registered on December 2024, and there are processes involved for ascertaining regarding the accusations relating to forgery of a title deed. I am of the view that for the purpose of the intricacies involved in the present case, the additional SP in charge of Dholahat Police Station or any superior officer in charge of Dholahat Police Station will monitor the said investigation. The investigating officer on each and every 15 days will report to the superior officer in respect of the progress is made with regard to the steps taken. All efforts be exhausted for taking the investigation of the case to its logical conclusion within a reasonable period of time. With the aforesaid observations, WPA 27586 of 2024 is disposed of. Server copy.
My lord, supplementary affidavit may be kept.
After the matter is over, but কিছু লাগবে না। আচ্ছা ওই একটা জায়গায় যেখানে অ্যাডিশন উপরে অ্যাডিশন এসপি লিখলেন না or any superior officer ওইখানটা হ্যাঁ শেষের দিকটা মনিটর
additional SP in charge of Jolaghat police station with
or any superior officer of the same rank.
Of the same rank.
My lord, can I get a copy of the report, my lord?
As a copy of the report be handed over to the learned advocate appearing in for the petitioner. Next.
I'm handing it right now.
The report be handed over to the learned advocate appearing for the petition. The report submitted be kept with the record petition. I need to argue. Yes, next.
21.
I am for the petitioner. I am the owner of the plot of land, my lord. But private respondent has assaulted us, my lord, to grab my property, my lord. Page 47, my representation, my lord.
Hey, Mr. A. Manuvaras, assaulting for property. Huh?
Already we have filed this with my lord. They have purchased in 2013.
It has been dismissed. Page 46, my lord. Page 46. Suit has been dismissed.
Suit dismissed. Suit dismissed.
My lord, dismissed. Therefore, it is my lord.
Restored. Restored.
And that is they are not disturbing, my lord.
Yes, Mr. Shengupto.
It is an undemarcated portion of the land is the point of the controversy. Now, Millard, the question is that whatever the prayer has been made by the Millard, the petitioners for providing the police assistance, Millard, this is not possible because the matter is pending before the Millard, the civil court.
Us, my lord.
The matter is pending before the civil court.
47, my representation, my lord.
Very good. Chalo. Petitioner is aggrieved by the fact that he is unable to protect his property because of the illegal act and actions of the private respondents. To that effect, information has been furnished before the police authorities, and in spite of the same, the private respondents are pursuing their act of disturbance at attempt to trespass and grab the property.
Us, my lord. I have stated, my lord.
When resisted, when resisted for such illegal acts, the petitioner has been subjected to assault. Even then, the police authority, is not taking a step. Learned advocate for the private respondent submit that already a civil suit is pending between the parties before the jurisdictional civil court. Learned advocate next. Learned advocate for the state, Mr. Sengupta, submits that in spite of submits that as the civil court is already in CCE of the issue, it is not possible for the police authority is to interfere in a civil dispute. Be that as it may, in case the petitioner feels that the nature of offense complaint of makes out a cognizable offense, petitioner would be at liberty to approach the jurisdictional court under section 175(3) of the BNSS. Learn a jurisdictional court will assess regarding the genuinity of the accusations and pass necessary directions. So far as the police authorities are concerned, they would keep surveillance and ensure that there is no breach of the peace or tranquility and or any untoward incident resulting from the strained relationship existing between the parties. With the aforesaid observations, WPA 27783 of 2024 is disposed of. You have a report.
Millet, the report, it doesn't speak anything. Millet, whatever the submission I have made, that is good.
ঠিক আছে this dispose of সাদা copies করে দেবেন regular order
22.
But in this matter, I am appealing for the state respondents, my lord. My
Yes.
lord, issue is, my lord, the IO of this matter, my lord, his mother is seriously ill in the 4th stage of cancer. He's out of station in Maharashtra now. My lord, may I seek for at least a 6 weeks accommodation, my lord, because he
exchange the affidavits in the meantime.
Hand over the supplementary affidavit, my lord.
আবার supplementary opposition করলো না
NIA is also
filed by the
supplementary affidavit filed by the petitioner be kept with the record. A copy of the same be handed over to Mr. Ganguly, learned advocate appearing on behalf of the state. Full stop. Let the affidavit in opposition in respect of the writ petition and the supplementary affidavit filed be 6 weeks you file the affidavit in opposition.
May I humbly submit?
Yes.
But all this charge sheet has been submitted, evading the Explosive Substance Act and the Arms Act, my lord. Kindly give some protection so that the investigation should proceed in accordance with law. But no trial should commence because once the trial being commenced, my lord, everything will be infructuous. My prayer will be infructuous, my lord.
Have you filed a further investigation prayer over there?
I had already prayed for that, but learned SCGM had not accepted because the matter is pending before this honorable court.
No, I'm granting you liberty. You go and file over there.
Lordship,
because sections are to be added over there.
Lordship, Mr. Majumdar is appearing for Union of India, Lordship, respondent number 1.
So ask the Home Ministry to add the sections. Why are you appearing only? আচ্ছা কি বলছে
Like affidavit in opposition in respect of writ petition and the supplementary affidavit filed.
Let the affidavit in opposition be filed in respect of the writ petition and the supplementary affidavit filed by the petitioner. Full stop. Within the 6 weeks চাইছে মোটামুটি চাইছে আজকে কত তারিখ by 8th of May 2025, affidavit in reply, if any. By 22nd May, possible?
My lord.
Some more time because IO, if it's not available, my lord, he has to affirm the affidavit.
You pray for extension. You pray for extension.
It's a serious matter.
Every matter is serious matter. পাড়া বোমাবাজিতে এনাই একে আনছে
Petitioner's brother died, my lord. For that reason.
20 by
Affidavit in reply, if any, by
22nd of May 2025. In the meantime, as a petitioner submits that charge sheet has been submitted by omitting relevant provisions of law. In case petitioner is aggrieved in respect of the charge sheet, petitioner would be at liberty to file an application under section. This is what, a new law or old law? New law. Huh?
New law. Yes, sir.
Under the relevant provisions of the BNSS for further investigation.
One prayer, my lord, kindly ask the state respondent to comply section 6, my lord. My prayer is that because
that they will say in affidavit. এখন কি করে বলবে? 6 দিয়ে কি হবে? 6 দিয়ে মিনিস্ট্রি অফ হোম অ্যাফেয়ার্স করে দিক না, তাহলেই তো হয়ে যাচ্ছে। এতদিন
everybody is telling that the matter is pending before the court, so we are not going to intervene.
List the writ petition under the heading to be mentioned. ওই 9th of June 2025. After reopening, I am keeping the matter.
9th of June. ঠিক আছে
23.
I'm appearing on behalf of the
Respondent
petitioner.
number 4.
Yes.
The state has not been served yet, so affidavit of service has not been prepared.
তাহলে ওই monthly list of July. Learned advocate appearing for the petitioner submits that state has not been served.
So for this matter is concerned, Lordship, kindly see the prayer.
দেখেছি আমি কিছু নেই।
Prayer A, my lord, and my lord, no case made out, my lord, no cognitive offense has been made out.
You are for the respondent number 4. Learned advocate for the respondent number 4 is
that state has not been served.
State has not been served. Acha, learned advocate for the respondent number 4, Mr. Mukherjee, is present. Full stop. In view of the submissions made by the petitioner, this the writ petition under the heading motion in the month list of July 2025. Sarag official
24.
Appearing for the state respondent lordship.
Affidavit of service, my lord, kept on record here. The private respondent also, my lord. The petitioner, senior
Lordship,
citizen,
kindly,
my lord,
lordship,
aged
before,
about, my lord.
before that, your lordship, kindly, lordship, have a look at page 55, your lordship.
That thing. Yes. Yes, Mr. Samir.
Petitioner is a senior citizen aged about 69 years, and petitioner's son is an MLA, my lord. And respondent number 9 here is daughter-in-law of the petitioner, my lord. They want to forcibly throw me out from my residence, my lord.
So where is the inquiry report?
Yes, my lord. That's the point, my lord. Page number 90, turn page number 54. That is the earlier division bench order.
Where is that inquiry report?
Lordship, before the inquiry report is with me, lordship, and the division bench headed by my Lord Chief Justice had decided the issue, which by placed by my learned friend at page 54, your lordship. Page 54. At kindly lordship, see at paragraph 4. Hence, the appeal stand disposed of by directing the respondent number 7, the officer in charge, but the one police station, to conduct an inquiry into the specific aspect as to whether the appellant has been prevented from running his office from the set one room, and whether he has been forcibly evicted, and thereafter proceed to take action in accordance with law. We have inquired the matter. There is no such lordship. Assessment is not correct, lordship. There is no one.
Have you communicated to them?
Lordship.
Never communicated to them. Me, thereafter, kindly turn my lord, page number 56, my lord. What happened, my lord, thereafter, my lord? I installed a CCTV camera.
That is also not true. That is found in working condition, which by default said the lordship.
Kindly turn page number 56, my lord.
All right, I've seen that. You give him a copy, let him use an exception.
I have given, lordship.
You use an exception, sir. The factual circumstances.
Yes,
Very
I want peaceful shelter, my lord, and I want to run my business peacefully.
That is what I am saying. Now you are saying you want to run, they are saying you are running the business.
Yes, I want.
Sorry, disputed question of fact is coming. You are saying you want to run the business. They are saying you are running the business.
Running the business,
peaceful residence, my lord. That's why, my lord, what action they have taken in regard to page number 56, my lord?
He's living in report. He's living in
although
and running the business, the Murshidabad on a daily basis.
Whether any action has taken by the police authority in respect of page number 56.
Yes, we have.
All right, you add materials in your Mr. Shamim. What you do is that you go through the report.
Yes, yes.
What are the falsity you are accusing? So far as the report is concerned, you take it up in your exception.
Yes, yes.
I'll dispose it of. 2 weeks time. 2 weeks.
That is enough.
2 weeks.
Lordship.
First of May, I'm fixing this matter. All right.
Yes, ma'am.
अच्छा ये state has submitted a report containing that the earlier direction passed in MAT 2519 of 2023 has been complied with by the officer in charge Budwan police station. ठीक है sir. Mr. Shamim Laner, advocate for the petitioner, contradicts the contention of the report. Accordingly, the petitioner would file an exception by 23rd of April 2025, rejoinder of any by 30th of April 2025, list the petition under the same heading for 1st of May 2025. All right. Mr. Yusuf, if there is difficulty, tell me, I'll extend the time.
All
right.
I get extremely good.
25. I am appearing for the respondent, my lord. Lordship, my lord was pleased to direct me to produce the case diary. Today I am coming with the xerox copy of the case diary, and today fixed for my lord framing of charge before the trial court, my lord.
Very good. So principal accused left out or arrested?
He is arrested. He is under custody, judicial.
Yes, sir.
Case of a brutal murder.
He is under custody, judicial custody.
Case of brutal murder. You tell me what is your grievance?
Because, my lord, it was earlier submitted before your lordship that the nature of injury, it could be detected that
the assault cannot be done by only one person. Usually only one person was arrested. And for that, this petition, an investigation officer is not conducted the investigation.
Oh, yes. All right, you submit your case diary. I will go through that. Let the trial go on. If order is required, I'll pass. The petitioner complains that the nature of injury, which is reflected in the injury reports as well as the postmortem report, do not suggest that the incident could be possibly done by only a single person.
Passing of your lordship's order, can there be a state?
Let it go on, sir. Nothing will happen. Nothing will. Now the law has been stretched. There is a proviso clause. You can pray for further investigation at any time. Ajab. Mr. Devroy, learned advocate, appearing on behalf of the state, has submitted a photostat copy of the case diary. Let the same be kept with the record. List the repetition under the heading for orders. On 21st. Next week, there are 2 working days actually. Thereafter, I'm fixing the matter. 21st of April, 4 orders. Maybe within a few days thereafter, I will take up the matter. Let me go through the case diary. 4 orders, 21st of April 2000.
26. All the issues involved in this writ application has been addressed and dealt with.
Yes, my lord.
The petitioner has been restored back initially at her home, thereafter in her bedroom as well. Thereafter, we have received the complaint. FIR has also been registered, my lord. So, my lord, the writ can be disposed of.
Yes, my lord. At this stage, nothing is remained, my lord. I have entered in my bedroom, and subsequently the private respondent started further upon me. And
you have a report, Mr. Ghosh.
Is remanded,
my lord.
Give it to my officer. Learned advocate. You are the private respondent.
6, 7.
I have used.
Since they have filed the supplementary affidavit, and I have not used any.
That has already been, but everything has
All
been.
right,
In the affidavit, the petitioner has admitted that the police have taken steps, and as on date, there are no further issues.
As a learned advocate appearing for the petitioner submit that in course of pending of the writ petition, appropriate steps have been taken by the police authorities, and at present, the petitioner has no grievance. Learned advocate for the private respondent and submits that since no affidavits have been used, the allegations and or accusations made in the writ petition be deemed to
Affidavit,
be.
there are no such allegations.
What he is saying, be deemed not to have been admitted according to him. Mr. Ghosh submits that police authority is Mr. Ghosh appearing for the state submit that police authorities have taken appropriate steps, and the grievance of the petitioner has been completely addressed. Considering the nature of submissions advanced by the petitioner and the state, I am of the view further pendency of the writ petition is unwarranted. Accordingly, WPA 28183 of 2024 is disposed of. Server copies. Sure.
Grateful.
Supplementary affidavit be kept.
About which is supplementary affidavit.
Admitting the facts that police has taken steps.
Yes, I have admitted the police has taken.
Supplementary affidavit file করে দিয়ে দেবেন first line টা filed by the petitioner be kept with the record. Copies of the same be handed over to both the parties.
I have already served.
Grateful, my lord.
Reports are submitted, be kept with the record for you. Come after 5 minutes, sir. Let me take a break.
My lord.
Report submitted by the police authorities.
The
report submitted by the police authority.
State be kept with the report. কত পর্যন্ত হলো? 26. Just 5 minutes break, thereafter I'm joining. Court notification.
27. Number 27.
I appear for the respondent bank.
Yes.
This is a case, my lord,
Allegation is not
that your,
correct.
that your petitioners, my lord,
Yes.
only a daughter of petition number 2 and was only son, that is the husband of respondent number 7, has already accidentally died, and he was an engineer and working during this working period accidentally died, and my lord, he was taking a loan over the residential house. Like, it was not knowledge about the petition number 1, because petition number 1
So
is
what
a
will please do? You go to the service, the tribunal, the tribunal concerns, sir.
yes,
What
my
police has got nothing to do.
here is a complaint lodge, my lord. Kindly come to that page. That is 43. On
Huh,
the
I am on that only.
Achha.
So what will police authorities do? Police have now petitioner complaint ends that the recovery agents have been in insulting,
Phone call. Only phone call
insulting
by
and abusing the petitioner and the family members, including the female folk. Full stop. Next paragraph. You are for the bank.
My lord, Padma is working on bank. That is the
respondent
branch of,
Acha. Learned advocate for the respondent and bank submits that the petitioner is a defaulter in respect of loan.
my loans, my lord. This is brother's loan. I am willing to, by taking a hearing of the representation, my lord, giving opportunity to repay my.
No. You go to the tribunal concerned under the Surface Act. Acha. Mr. Devroy, learned and advocate appearing for the state submits that police authorities have kept a strict vigil in respect of the accusations made. However, since the alternative remedy is available, the act of the bank authority is cannot be deterred by the police. Full stop. From the nature of the information submitted to the superintendent of police Pashchim Medinipur, it reflects that petitioner has an alternative remedy under the appropriate tribunal, under the another jurisdictional tribunal created under the Surface Act. So far as remedy are concerned, the petitioner would be at liberty to approach the say tribunal. However, the police authority would only see to the extent that no excesses are inflicted without the no excesses are inflicted as complaint of. With the aforesaid observations, WPA 28366 of 2024 is disposed of. Several copies. The reports are submitted. We kept it the record. Chalo.
One small intervention. Your lordship has specified the report to approach the your lordship has not specified the report to approach the next recovery chapter. Lordship specifies in accordance to the period of limitation also.
So you get an order from the ACGM, take your steps, sir, or whichever authority, sir.
28.
Yes, madam. Use the microphone.
Children is deprived from a child.
The respondent number 5 is a father. You have got to apply under the relevant provisions of law. What will police do? Respondent number 5 is the father.
Yes, my lord. And
Child is with the father. a legal guardian. Huh? How can police go and interfere?
Mother is a child.
Huh?
Mother is a child. That is the constituted. The petition constituted. Amkhana. Respondents constituted. The petition. Mother.
It's dispute between the mother and the father with the regarding the child, basically.
Yes.
So go under the guardian and what's that, sir? What can police do? Petition.
They are illegally.
Use the microphone. I can't hear you.
She only want to meet her child, but they are illegally preventing him to enter into her in-law house.
So where is the order of a court of law? Get an order from a court of law. Unnecessary dispute and difference will arise. Petitioner claims that the child has been illegally detained and she is not she has not been allowed to meet the child. Full stop. Records reflect that child is with the respondent number 5, who happens to be who is the father of the child. Since the child is with a legal guardian, the police authority will not be able to interfere without an order from an appropriate court of law. Full stop. Petitioner would be better advised to approach the civil court under the relevant provisions of law. If the civil court is a direction, the police authority would then ensure that the same is compliant with in accordance with law. So, with the aforesaid observations, WPA 28416 of 2024 is disposed of. Server copy is next.
29.
The order of the landed civil court, my lord, and thereafter, my lord, page 59, direction upon the police. Police is not complying with the direction of the honorable.
Yes, what happened?
My lord,
why is the police not complying with state?
Police is creating trouble not to allow me to enjoy my property and to enter my land, my lord.
Yes.
That's why the whole problem is created.
All right, let the state answer. Yes.
My lord, your lordship.
Wait, let the state answer. Yes.
107 will not.
No 107, sir. You have got to comply with the civil court's order, or you pray for alteration of the civil court's order.
All the FIR, my lord, and the investigation is going on.
My lord, my
title suit is going on, my lord, case 55, my lord, and there is a injunction, my lord, till a certain date, my lord.
Page 59 also, my lord.
How have you complied with the order dated 30th August 2024? There is a specific direction. Records reflect that by an order dated 38th August 2024, the learned aid civil judge junior division Kaldeep passed a direction.
Page 59 also, my lord.
Wait, sir.
59. Specific direction upon the police.
Kivalam?
Civil administration Kalki passed a direction.
Passed direction for advocate commission. Thereafter, on 5/9/2024, no, 5/9. Thereafter, on 11/9/2024, the petitioner, an application was filed by the petitioner of the plaintiff for maintaining strict vigil by Dholahat police station, which was allowed by the learned civil court. The title suit number in TS number 210 of 2024. State has submitted a report which reflects that the police authorities have drawn up proceedings under section 126 of the BNSS against both the parties. The 107 earlier proceedings were drawn up on
Not able
section
to enter.
107 of CRPC. Wait. Acha. Subsequently, Dholahat PS case number 480/24 dated 16/8/2024 was registered for investigation under the relevant provisions of the BNS. Full stop. Acha. The steps which have been taken by the police authority are in respect of violations. However, the police authorities till date did not abide by the order passed by the London Civil Junior Division on Kakdeep. Accordingly, all right. Accordingly, police authorities are directed to implement the order passed by the Learned Civil Junior Division on Kakdeep until and unless the same has been altered by any higher forum. Full stop. In case the police authority is facing any difficulties, they are supposed to submit their report of inconveniences faced by them before the Learned Civil Junior Division on Kakdeep. In the alternative, they would respect, obey, and implement the orders passed upon them to be executed. Full stop. Chalo. With the aforesaid observations,
Police is to be directed, my lord. He is not allowed. Police is not allowing me to enter my land and to enjoy the.
that is the direction I have passed, sir, already. They will
Lord.
execute the order of the civil court.
And the report is to be handed over to me.
WPA 284459 of 2024 is disposed of. Reports are submitted. Be kept in the record. Copy of the report be handed out to an advocate appearing for the petitioner. Sure.
Order number 30.
Here, my lord, in terms of your lordship's directions, I have sent a written complaint, and on the basis of my complaint, police has already taken steps. But there is the thrust of private respondent to make again the similar occurrence.
Petitioner submits that during the pendency of the writ petition, an information was furnished with the police authorities, and the police authorities have. You have registered a case, Mr. Ahmed?
But there was no specific written complaint by the petitioner, my lord. But in spite of that, when we have made inquiry into the allegations of the petitioner, my lord, we have already initiated 126 of the BNS Act, my lord. It's a private dispute, my lord, between the
No,
parties.
but they say police have taken steps means what?
We have steps in respect of the allegations, my lord, not just verbal allegations. There was no written allegations by the petitioner.
So subsequently, they say that is
terms of your lordship's directions, I sent a written complaint.
Right.
And supplementary affidavit. Your lordship directed me to file supplementary affidavit.
My lord,
so what steps have been taken by the police authorities?
My lord, just key
Private respondent are not making any disturbance at present.
It is published that during the pendency of the writ petition,
one NCR, my lord, we have submitted one NCR, my lord.
Information was published with the police authorities, and the police authorities have
taken steps for which presently the private respondents are not disturbing or interfering with the
land of the petitioner.
Land of the property of the petitioner. Also, Mr. Ahmed submits that Mr. Ahmed appearing for the state submits that proceedings have been drawn up under section 126 of the BNSS.
And we have submitted NCR number 181.
And a street vigil has been kept at the local. So that no unnecessary so that no untoward incident takes place. Be that as it may, As the petitioner presently is satisfied for non-interference at the behest of the private respondents, I am of the view that the further pendency of the writ petition is unwarranted. In case further inconveniences are faced by the petitioner would inform the police authorities who would act in accordance with law. With the aforesaid observations, WPA 28771 of 2024 is disposed of. Server publisher.
Good.
Yes, Your Lordship.
Yes.
My primary allegation was that the private respondent abusing the girl, female members of my family, pursuant to which I lodged a complaint. FIR was drawn up. So, subsequently, I got information that charge sheet in connection with that case has also been filed by the investigating agency. So, I will take recourse before the learned court below. One innocuous prayer, as the the abusing languages are being used over there. Let police make a search vigil over the property so that no untoward incident could be taken.
Petitioner complains that the female were being threatened, abused, and hurled with filthy languages. To that effect, information was furnished, and a criminal case was registered by the police authority.
I submitted the report, Your Lordship.
Subsequently, charge sheet has already been submitted in connection with the said case. Considering a petitioner submits that he has some grievance in respect of the charge sheet which has been submitted. Full stop. Learned advocate for the state has earlier submitted a report which reflects regarding the steps taken by the police authority and the vigil which has been kept to prevent any untoward incident. Full stop. Police authorities would continue their surveillance so that no further untoward incident results or there is any aggression at the behest of any of the parties. So next, petitioner is aggrieved regarding the charge sheet which has been filed before the jurisdictional court. To that effect, petitioner would take steps under the relevant provisions of the BNSS if and the London magistrate would assess whether further investigation is required under section 193.9 of the of the BNSS. With the aforesaid observation, with the aforesaid of the WPA 28785 of 2024 is disposed of.
Report may be taken on record, Your Lordship. Report I have filed.
Report submitted, we kept with the record. Actually,
only one
copy of the report we handed over to London advocate appearing for the petitioner.
Last line, Your Lordship directed that petitioner was abused. Well, a family member of the petitioner.
Petitioner, family, woman folk, I have said.
Deeply obliged.
Next. Yes.
Yes, my lord. I got the report, my
That due to unauthorized construction made by the private respondent upon the PWD land, that I could not enter my premises. Now, I filed a writ here to demolish the entire his unauthorized construction. But since I filed the writ, he threatened me to.
That petition is pending.
Yes, unless I withdraw the writ application, that they will kill me. And then immediately I filed the complaint before the police.
Petitioner is aggrieved as
120 PNS, my lord, have already been filed, my lord.
Petitioner is aggrieved by the is aggrieved.
I have already filed the report, my lord.
Is aggrieved because the petitioner was obstructed from entering his property because of an illegal construction being made at the behest of the private respondents. To that effect, petitioner filed an application, filed a writ petition being WPA 24784 of 2024 Immediately, immediately on the said writ petition being filed, the private respondent and started threatening and abusing the petitioner, for which the petitioner was feeling insecure, and in spite of informing the police authority, no steps were taken. Learned advocate appearing for the state has submitted a report. Report reflects that a proceeding under section 126 of the BNS was drawn up by the police authority is for maintaining peace and tranquility. Full stop. Okay. Since steps were taken by the police authority is in respect of the threat and abuses complained of by the petitioner, I direct that the petitioner would continue to keep a strict vigil and ensure that no untoward incident results between the petitioner and the private respondent because of the strained relationship in between them. With the aforesaid observations, WPA 28813 of 2024 is disposed of. Reports are submitted, be kept with the record. Copy of the report be handed over to the learned advocate appearing for the petitioner. So next.
After three.
My lord, you had told me to submit an affidavit for appearing in person. I have got the affidavit and I have obtained the no objection from Mrs. Mithu Bhattacharya.
Madam, your application are same applications. What is your new application?
Sir,
you have earlier filed a criminal case.
It's a different case, sir. There is a criminal case pending against respondent number 5 against Momita Ghosh. C 200 it's under section 120B 34 420 IPC. Criminal case has been pending since 2019. I have informed the concerned department officials, DHS, DD admins, CMOH, ACMOH, BMOH with the related case papers of the court to do the police verification and take necessary step and to stop the illegal stealing. But the concerned department, along with respondent number 5, have done a suppression in the police verification report. Please come to page number 41. Please come to page number 41.
Yes.
The concerned department personnels have written, no record is found at present at the concerned ACMOH office, that is ACMOH Arambagh, in respect of completion of PVR. But there is a criminal case pending against respondent number 5.
That is not within the classification of this court.
Then, sir, I have informed the police authority that they have done a fraudulent activity because PVR, I went and told the
Where is that? You tell me these are all to the different departments. Where is that? I find from the records you have filed 156.3.
Sir, I have informed the concerned police. It is on page number 28, sir. Page number 28.
Yes, that's of 9th of July 2024.
I have been informing, but they have not taken any action regarding the fraudulent activity done in the issuing of the PVR certificate by the concerned department. They have done a severe suppression of the criminal case which is pending against respondent number 5. I have informed them with the concerned case papers, sir, of the court. Every related case papers have been submitted to the department. I told them.
Department?
The Department of Health. Respondent.
The Department of Health, I cannot do anything. That is not my determination.
But the police, sir, but I have done inaction of police because it was the duty of the police to investigate, because police was in duty to see that that the PVR suppression, whatever that they have done, the criminal case suppression in the PVR. They have done a fraud.
They means who?
Please
They means who?
Respondent number 6, 7, 8, and 9.
So the respondent number 6, 7, 8, and 9 are authorities against whom police authorities how can they initiate a case without a sanction?
because the in the PVR they have done the suppression of the criminal case. Then if the police should be into action to see that who have issued the PVR certificate.
You file these are all public servants. The respondents you have referred to are all public servants, basically.
But they have done a severe fraudulent activity, sir. I request you to tell the Khanakul IC to take necessary action because he has not taken any action. I have been informing him several times.
You go under, there is a specific provision under section 175(4). Your offense you complained of is on 9th July. Pursuant to the new act coming into force, you go before the learned ACJ Arambagh. This is which Khanakul is under Arambagh. ACJ Arambagh.
Sir, the lady is posted right now in Khanakul Rural Hospital. The BMH also has been, they have enhanced the corruption of illegal stealing, sir. And in spite of telling them again and again, Khanakul IC was not taking the complaint seriously, and the corruption of illegal stealing is getting enhanced every month.
You go to the learned magistrate, there is a magistrate, you go 175(4) BNSS, you file the accusations before the learned magistrate. He'll do the same.
Khanakul IC also had not taken any action.
And IC, if they don't do, that is what the provision I'm referring to, madam. These are public servants, they are reluctant to do. Learned advocate appearing for the learned advocate. Petitioner appears in person and submits that there has been inaction of the police authority is as the Chief Medical Officer of Health in his reply to the RTI application on 13/3/2024 filed reported it incorrectly in respect of the criminal case which is pending against one Dr. Momita Ghosh. Petitioner further alleges there are issues relating to fabrication of records, cheating, and other allied criminal offences. Petitioner further alleges that the respondent numbers 6 to 9 are responsible as they are trying to shield the offender, and it's possible that they are hand in gloves with the delinquent. Full substate has submitted a report in respect which encloses the previous accusations made by the present petitioner.
Page 3, my lord, where it shows that when complaint has lost. Second paragraph, my lord. Complaint petitioner first time lost complaint on 9 July 2024. Accordingly, we have taken step in page 4, my lord.
How can you? Page 4.
Report, my lord. Report, in my report. Page 4.
Where is that?
My lord.
Where is that?
That police station, Sonapur police station, case number 1253 of 2014. And
So that is a 2014. That is a different incident.
It's about 6
That's a 376 case, different incident.
Yes, during the pendency of that case, accused have done further crime. So see 200.
All right, all right. State has submitted a report which reflects regarding the previous cases instituted at the behest of the petitioner and the steps taken by the police authorities. However, so far as the present informations which have been furnished on 9th July 2024, I find that no steps have been taken as the police authorities complained that sufficient documents could not be placed before them. Also, having considered the plight of the petitioner, I am of the view that the petitioner would be at liberty to file an application under section 175 bracket A4 of the BNSA AAs before the jurisdictional criminal court.
Puchura, most probably, sir. Puchura.
Huh?
Sir, presently the lady is stealing from Khanakul Rural Hospital. Khanakul Hospital. So that's under Aramba Court or
I've said jurisdictional criminal court. You go to the appropriate court. Whether it's Khanakul, is Arambag or Chinsura, you can go to the CJM Hooghly also, no issue. I've given jurisdiction, whichever is the jurisdiction concerned. Jurisdiction,
This is 175 of the BNSS before the jurisdictional
criminal code, full stop. The learned aid court would assess as to whether any cognizable offense has been made out, comma, ascertain whether a case for investigation is made out, and thereafter pass necessary directions by exercising his discretion. With the aforesaid 8 observations, WPA number 29072 of 2024 is disposed of. Report is submitted. We kept with the record. Copy of the report be handed over to the learned to the petitioner appearing in person. Serve a copy. Sure.
Thank you. Sir, thank you.
175 bracket 4. Next.
34. Before your lordship has directed me to submit a report in the form of an evidence. I think you share before your lordship. Kindly see the evidence page 7, lordship.
This report evident के नाम तो बोलो ना evident check the state. Yes.
Fine. Your lordship, first of all, kindly comes to page 5. You know, the petitioner is directly involved in a defalcation case where an amount of almost 1 crore 80 lakhs has been defalcated from various customers. And it has been found that from the defalcated account, money was transferred into this account, from where he has purchased several plots of land. Now your lordship kindly comes to page 5 of my report. Lordship kindly G. That further on 142023, the branch manager of HDFC Bank, Aliagan Bank, so reported case and filed yet another complaint, and again, as per my order, the state complaint was tagged with this case for investigation. Now, my lord, that during investigation H, that during investigation of development case, it was revealed that the petitioner from Laha is directly involved with the branch manager and other officers of HDFC Bank, Aliagan branch, so and so, who have been already arrested in this case. As a result, despite not having bank account at HDFC Aliagan branch, petitioner had a secret communication or relationship with Apurva Ghosh, who is Porchaj, Savuni Shah, who were the then staffs of HDFC Aliagan branch. That as a result, so far to bank account, that is not, that's not relevant. It is relevant. Now, Lord, page 7J. That during further investigation of the case, it was revealed that in their said Uttam Laha purchased more than one landed property by the default.
It's all right. What are you wanting, sir?
My land was not registered the registry officer. Lordship, kindly see the page, Lordship, 7, Lordship, of this affidavit, Lordship. It is pertinent to mention that on 13th January 2025, a prayer has been submitted before the court of the learned CTM Raiganj, Uttar Dinajpur, in connection with the attachment of land property, Lordship. Lordship, they filed January, Lordship. My application was filed of this honorable court December, Lordship. The order of the concerned CGM is in page 14 of my reading. Page 14. IO is directed to give further details about the track of siphoning incurred and the defalcation of fund of the.
No, Mr. Ghosh, you tell me for attachment you took permission from the court. For attachment.
We have paid for the attachment.
Where is that?
It is in page 12. Page 12. The relevant part is in page 13. Under
Yes.
the circumstances that pay before your kind honor, the necessary order may be passed for attachment of the same landed property of accused Uttam Maha, who has mentioned above, which was purchased during this period of so and so for the interest in investigation of the case. Investigation of the case is quick.
So, sir, the order has been passed by the magistrate.
Right.
What will police do? Go for revision of that order.
At the time of this application was filed, Lordship, they not go to the trial court.
What? Huh?
He is trying to say that these things have developed subsequently. But this was the part of the investigation.
But if FIR was got on 2022, Lordship.
All right, you go before the revisional court, sir, and agitate your points so far as this is concerned. Because magistrate has passed an order, you go for revision of the order. Petitioner, the state has submitted the report in the form of an affidavit. You have been served with a copy.
Yes.
The same has already been served upon the learned advocate appearing on behalf of the petitioner. Petitioner approached the court being aggrieved by the action of the police authorities. However, the report also submitted reflects that information was furnished to the learned CJM Uttar Dinajpur, and thereafter steps were taken for attachment of the property. Full stop. If inconvenience are faced for attachment of the property, pursuant to a direction of the court, the proper course of action would be for the petitioner to approach the revisional court in respect of legality or illegality of the order so passed by the learned magistrate. This court under Article 226 of the Constitution of India will never interfere in respect of a step taken by an official under a particular statute. Thus, petitioner, if so advised, would approach the revisional court. No further order needs to be passed in the present writ petition. Accordingly, EWPA 29082 of 2024 is disposed of. এটা বলেছি রেকর্ডে লিখে দিয়েছি না affidavit report in the form of affidavit filed by the state, we kept it the record survey.
35.
Affidavit of service. Lordship will kindly take up page 64 once, Lordship. Lordship, this is against the non-implementation of the orders repeatedly passed by the learned civil court. This specifically at page 64, Lordship will kindly take up that prayer for police help under 151, dated this and this is considered an allowed ex parte. IC Chagda PS is directed to look into the matter so that the order of temporary injunction passed by this court is complied by the parties and send a report thereof. Lordship will kindly take up the temporary injunction order at page 53 and 54. Lordship, this is a heart. Lordship, this is the private property of the respondents. They're the co-sharers. They're in management of the heart. Now there is a Shomiti, the private respondents are for days together. They are collecting the rents. They are not allowing the original owners of the land to enter into. Lordship, this is an order of temporary injunction at page 54. Which specifically says that temporary injunction is considered and allowed on contest.
Yes, state. What is this? I see as if you are not possible, you tell the court.
They are actually managing the heart. Petitioners have gone there for collecting the khajna.
No.
So that, whatever it is, that cannot be decided by the police authorities. That is to be decided by the civil court.
collection of rent has been decided.
What police injunction is there? If they are any violation of the order of this injunction by the Supreme Court passed, they can go for under order 39 to ignore. They are
Lordship, we have exhausted. Lordship will kindly.
A question to myself, why is the election of police? If there is a violation of this court order, there is a provision on this court, they can and they could have gone. They are not gone.
Lordship, I will.
The whole management is being controlled by the Bajar
Lordship will kindly.
That I will not enter into, sir. If you have got to say anything, you should have submitted a report before the civil court concerned
Lordship
for clarification.
Lordship will kindly.
Where have you filed the report before the civil court?
No, Lordship will kindly hears me, Lordship, for 2 minutes. Lordship, thereafter, Lordship considers their submission. Lordship will kindly take up page 54, the last line. Just a minute.
I've seen that 54.
Also from obstructing plaintiff from collecting rent and other charges from the vendors, shopkeepers and traders running business at Shingerad.
Alright, you submit your report. Mr. Ganguly, submit your report.
And Lordship,
Petitioner has drawn the attention of the court to the order
whether this court can entertain
order
the
dated 11/2/2022, passed in PS 132 of 2020, which is as follows. Page 54. Subsequently, petitioner has drawn the attention of the court to the order dated 13/3/2024. Footstep. The petitioner thereafter submits that in spite of direction passed upon the inspector in charge of Chakda police station, they are defying the order of the civil court, and the petitioner is unable to manage the day-to-day affairs and including the factor of collection of rent, as was directed in the order of injunction dated 11/2/2022. Poster Mr. Ganguly, in an additional government plead appearing on behalf of the state, submits that the report which has been submitted by the police authority is reflect that the market of the heart is being managed by a different set of people and not the petitioner. Be that as it is, police authorities are not supposed to decide against a verdict or a direction passed by a court of law. If the police authority faces inconveniences, they are supposed to submit a report in respect of the resistance faced by them or complying with the order of a court of law. Since I find in that there is a specific direction of the inspector in charge of the police station until the said order is modified or set aside, modified by the same court, or modified or recalled by the same court, or altered by any higher court of law, the inspector in charge Chakda police station will implement the order dated 8/13/2024, passed by the learned civil junior division Kolani Nodia. Full stop. With the aforesaid aid observations, WPA number 29183 of 2024 is disposed of. Reports are submitted. Be kept with the record server copies.
Yes, and there they have acceded that.
I have given all the options to both the users. Police, I have given all the options. If you have difficulty, approach the court. If you are otherwise, if the court does not alter the order, you cannot interpret the court order. You have got to implement the court order, sir.
The violation of the order. It is that in that sense it is not understood. It is not. I am equipped with the judgment where there is a temporary injunction order. Court has adjudicated on the rights.
Completed. Next. Without father was also saying. State who is appearing? State State.
I am here.
Yes. Mr. Sen, your office, any steps have been taken?
So far, this petition is concerned, Lordship, the prayer is there. That with regard to my lord, that the police assistants for their my lord, the peaceful stay in their own residence. One of the prayer is this, that they could take necessary steps on the basis of the complaint. Complaint was there, my lord, we have taken steps and family member can safely stay. Now, my lord, in terms of the report says that nobody charged us except that the filing a complaint and what we have taken steps and my lord, the case is pending. But the letter of my lord, in place case they filed the petition number 30802 of 2024 after this. And my lord, there the same prayer was as it appeared because I did not appear in this matter, but it appears from the my lord, the order sheet that the my lord's order was there. In that order dated 17th of January, in that subsequent petition, that the main grievance of the petitioner is that petitioner's husband was mercilessly assaulted. Prior to that, they were neglected, and the petitioner further submit that lastly on such and such, a group of persons ransacked their house, and my lord's order was that, be that as it may, in case the petitioner and her husband were earlier staying at the premises referred to in the petition and were removed at the behest of certain persons without authority of law and without any consideration, in that case, if the petitioner and her husband approaches before the concerned authorities, the police authorities would assist the petitioner and her husband to enter into the premises. Now, my lord, my instruction that after this, in that order filed by your lordship in the subsequent petition, my lord, they did not turn up to the my lord, to the police authorities.
We turn up, we already filed a contempt application.
Since my lord,
the order is not even complained.
So far, this complaint is concerned.
All right. Problem is to be solved, sir. No use keeping. You go, police authorities will comply the order. Mr. Sen.
Nothing remains in this petition.
Any date, your lordship kindly fix on any date. All right,
All right. All right. By 16th, you go to the police station. They will comply, and a fresh report be submitted on 21st when the matter will appear under the heading to be mentioned. Done.
It's the 21st, 1 day.
22nd. All right. There is a dispute regarding non-compliance of an order passed in WPA number
30802.
30802 of 2024.
2024. Already disposed of.
Very similar, wherein the allegations of the petitioner were in respect of being thrown out from the house at the behest of the private respondents, and there were directions by the court to be restored in the background of the facts placed by the petitioner. However, Mr. Sen, learned aid advocate appearing for the state submits that the petitioners did not turn up in the police station. Mr. Bhattacharya, on the other hand, appearing for the petitioner, complains that in spite of repeatedly going to the police station, no assistance was received. In case such a situation exists, petitioner is directed to approach the which police station?
Mondirbajar police station.
Mondirbajar police station, who would try to comply with the directions passed in the writ petition. ওই WPA নাম্বারটা দিয়ে দেবে, ওই আগেরটা এটা আছে, হ্যাঁ। Mr. Sen submit police station on 16th of April 2025. A fresh report submitted before this court on 22nd of April 2025 when the writ petition will appear to be mentioned. When the writ petition will appear under the heading to be mentioned. 22 তারিখে 22 তারিখ। Next.
37.
7 minutes, I am for the petitioner.
And the private.
So the petitioner made a complaint before my lord.
Up to item number 40, I will take. Rest you can come after recess. Up to item number 40. Yes, sir.
The petitioner, my lord, made a complaint, my lord, before the police authorities, my lord, which is at page number 11. My lord, no
The
steps.
land dispute matter. Why do you come over here, sir?
Yes, yes, yes. My lord, I am only relying on my lord one. My lord, may I, my lord?
Yes, yes, you carry on.
My lord, kindly, my lord, comes to page number 22, the last paragraph.
22.
22. Annexure 3.
Yes.
Well, the police, my lord, admits, my lord, the second last paragraph, my lord, that during local inquiry, it came to know that there is a possibility of serious breach and peace. My lord, my lord, steps be taken, my lord, according to their merit. My lord, my only prayer is, my lord, my lord, steps be taken according to the admission, my lord, they have made.
So, petitioner, although has taken up many issues in the writ petition in respect of the property complained of, however, has restricted his prayer before his court after relying on an earlier report submitted before an executive magistrate that in respect of proceedings under section 126 BNSS being drawn up for maintaining peace and tranquility. Full stop. Mr. Ahmed, learned advocate appearing for the state, is present, having considered the submissions and the fact that there is a dispute and difference between the petitioner and the private respondents. I direct that the police authority would keep surveillance and ensure that no breach of the peace and no tranquility takes place and not any untoward incident results because of the inimical relationship existing between the parties. With the aforesaid observations, WPA 29514 of 2024 is disposed of server purpose.
Already been acquired by the government in the year 2177-78.
Which one?
Item 37.
37 NIA चाहिए
Acquired by the government.
Huh?
Government has already acquired that land, which is my land. London friend is praying for 37, item 37.
Who is for the state?
Item number 38. Your lordship had to take up item number 38. My learned friend is mentioning the matter of item number 37. The order which has been just now been passed by your lordship.
You are for respondent number?
Respondent number, private respondent number 4567.
That has been, government has acquired the land.
Yes, my lord.
Then you are unnecessary party then, if it's the land. Landed advocate for the private respondent submits that the land which has been referred to has already been acquired by the government. Acquired by the government. As such, the private respondents have no role to play for creating any disturbance or encroaching upon the said property as complained of by the petitioner.
38. 38, my lord, I'm appearing for the petitioner. My lord, on the last occasion, my lord, the SP was directed, my lord, to submit an report in the form of an affidavit. My lord, with regard to the steps taken on the complaint which has been lodged by the petitioner, my lord, since she was a victim of a bomb attack, my lord, and as well as produced the case diary of case number 991, my lord, which is a suo motu case started by the police, which gives a different version, my lord, to the complaint which I have lodged. It is not.
Take some time. I'm putting it under a for orders. All right.
I already filed the report on behalf of the respondent number 3. Right?
That is SP's report.
Right? As per my lordship's earlier direction, I am filing this affidavit filed by the SP respondent number 3.
By way of an affidavit.
Yes, yes.
But lordship, can you inquire whether on the basis of my complaint they have registered an FIR?
In the motion stage, don't pray. You know how much things are pending.
Well, lordship keeps it under the heading for orders, and I have no problem.
Mr. Mukherjee, learned advocate, appears on behalf of the petitioner. State has submitted an affidavit a report in the form of an affidavit of the superintendent of police. Respondent bracketed respondent number 3. Full stop. Case diary is also available. Learned advocate for he's for Union of India.
Union of
Learned advocate for the Union of India is present. Having consider the time required, the paucity considering the paucity of time, let the petition be listed under the heading for orders. when the party is would be ready for addressing their grievances. It's the repetition under the heading for order as on 28th of April 2025. 28.
Your Lordship,
Yes.
it's
17 many matters are there. Chola,
39.
I am for the bill.
I am appearing for the state, my lord. I am submitting a report, my lord.
There is a long-standing dispute between the petitioner and the private respondent. My lord. Earlier occasion, the private respondent tried to demolish my house, my lord. I have lost complaint. FIR was started.
And now?
Subsequently, now the private respondent sending his minor son to take photograph of my private place of my
What have you done, sir?
This is a dispute over the common boundary wall between the petitioner.
Photographs,
and the private
photographs. Have you found photographs?
That is a civil dispute, my lord. Anyway,
Are photograph civil dispute now? Embarrassing photographs they are taking up. Objectionable.
That I don't know. Police has taken steps, my lord. Started cases.
Have they found the allegation to be correct?
No, 126 cases started. And peace is being maintained in the locality, and the police has
Petitioner submits that earlier informations were furnished before the Burdwan police station, consequent to which Burdwan PS case number 465/23E dated 16/4/2023 was registered for investigation. Subsequently, again, the son of the petitioner was taking photographs of the female members, which was objected by the present petitioner, and for which he was abused and threatened. Learned advocate for the state submits that there is a long-standing dispute with regard to the boundary of the demarcation and construction of boundary wall at the property. Police authorities have already drawn up proceedings under section 126 of the BNSS.
Yes, and peace is being maintained at the locality.
And peace is being maintained by the police authorities. Having regard to the nature of the accusations, I am of the view that the police authorities presumably have not inquired into the same. Accordingly, if the petitioner is aggrieved by the inaction of the police authorities, he would be at liberty to approach the jurisdictional magistrate under section 175(3) of the BNSS. Learned magistrate would assess and ascertain whether investigation is called for and thereafter pass necessary directions. In the meantime, police authorities would ensure that there is no breach of the peace and tranquility and or any untoward incident resulting from the inimical relationship existing between the parties. With the aforesaid observations, WPA কত নম্বর ওইটা করলাম? WPA 29980 of 2024 is disposed of. You have a report?
I handed over a copy, my lord, to my lord.
Reports submitted, we kept in the record. A copy of the report we handed appearing to the petitioner. Yes.
40.
Respondent lordship.
I am appearing, lordship. I am filing the affidavit in service.
Yes.
Dispute arose from a landlord tenant dispute. Now, on the 20th day of June 2024, the IC of Rampur police station came in civilian clothes and arrested me from the place which it was leased. And at around 7 p.m. at night, I was taken to the police station on force, though I did not want to go. And subsequently, the IC told me to submit a certain amount of money to the police station so that he would not file any FIR or any complaint against me. I was detained in the police station for 2 days. On the 24th day of June, FIR was filed against me, and subsequently I was produced before court. Like on the 24th, I was detained in the police station for 2 days. I was not on the 24th. I was not served with any 41A notice or
so
any.
You filed an application under 175(3).
I have filed an application under 175(3), lordship, but then the application was dismissed of stating that.
So how will 226 lie when a divisional jurisdiction is available?
Lordship, the application has been disposed of saying that it's not maintainable because I have not
How?
sought the
So
permission.
how can this against the rejection order of a magistrate, 226 will come in?
Lordship, I'm praying for the fact that an investigation can be registered. Be
As
held.
an investigation, you got to set aside that order first. I'm not a revisional court. Yes, Mr. Yusuf.
Lordship, on 24th June 2024, Lordship, the petitioner forcefully entered into disputed places and Lordship and threatened the private respondents.
Already submit the report. This is not maintainable on question of law. It's not
We have also
maintainable.
issued the 41 notice.
Whatever it is, sir, whatever it is, that you explain, this will go, alternative remedy is available. 226 cannot be invoked in this case. Petitioner is aggrieved by the police excesses.
One submission, Lordship, we have registered the case, Lordship, FI.
Now?
No, on that day, on 24th June, your Lordship.
No, 24th June is not the problem. Probably aim
After, Lordship.
Petitioner.
By the police excesses.
Excesses. And as urge, file an application before the learned aid magistrate under section 175(3) of the BNSS. Learned aid magistrate on an appreciation of the learned magistrate being the learned ACJ in Birbhum. Rampurat Birbhum. কি বললাম learned
It's 175(3) হয়ে গেল learned magistrate being the learned ACGM Calcutta Birbhum.
On an appreciation of the materials, place was pleased by an order dated 25/10/2024. Dismissed the said application being MP case number 270 of 2022. Acha. Mr. Yusuf appears on behalf of the state and submit is that the police authorities adhere to the provisions of law. So without going into the merits of the police report submitted before this court, I am of the view that since the petitioner is raising the said contention, which was considered by the learned ACGM Rampura Birbhum in an application under section 175(3) of the BNSS and rejected. The petitioner, if so, the petitioner has an alternative and efficacious remedy, as a revisional application is supposed to be filed against the order so passed by the learned aid magistrate. Consequently, I am of the view that the writ petition is not maintainable. Petitioner, if so advised, will approach the jurisdictional revisional court. Accordingly, EAWPA 30607 of 2024 is dismissed. Reports are submitted by the state be kept with the records of our petition.
I'm grateful, Lord.
Come after recess, sir.
Bye, Lord.
কত 40 পর্যন্ত হলো আমি বন্ধ করবো
May it please your lordships.
Yes.
My lords, I have a matter where your lordships granted leave yesterday. It's at 392. If my lords could deem it appropriate, my lord, to take it up anytime
This
sooner.
is the original side going on.
Please, my lords. I have, my lord, I've come from Delhi actually, my lord, physically, but then I came to know your lordships are appearing. Your lordships are in chambers. So, my lord, I thought of it. I have a flight back to Delhi, my lord, at around 4:15. If my lords could accommodate me by 3 p.m., I'll be grateful, taking 10 minutes, my lord, maximum.
But then today you shouldn't have come actually.
All right.
Original-
So, my lord, if your lordships could consider any day, that's your lordships could. It's a, my lord, arrest matter. Tomorrow, my lord, if it's a, my lord, I am saying that I am covered by, my lord, now the Supreme Court. The, my lord, the arrest under PMLA, this is, my lord, I'm challenging the legality and validity. So maybe, my lord, the other side would like to file a short reply also. So if your lordships could, my lord, consider taking it up today or tomorrow morning, my lord, anytime.
I cannot say because that's an appellate side matter. May not be possible for me, but just keep a watch tomorrow in the morning.
All right, my lord.
Thereafter.
My lord, then I'll seek your lordship's leave to appear through VC tomorrow, my lord.
Definitely, please.
Deeply obliged, my lord. Deeply obliged. Deeply obliged.
Original side item number 1.
State. Petitioner hasn't turned up, is not appearing since the month of January itself.
21st of May, standard date. None appears for the petitioner. Learned aid, advocate aid for the state is present. Except state, anybody is there?
No, none is appearing. No one is there. State is the only party, and report is also been submitted.
Accordingly, list the petition on 21st of May 2025 under the same heading.
Lordship, the writ petitioner is not appearing since the month of January itself.
But he is in person appearing. Let him be given certain opportunities. স্টেটে ওখানে কোর্টে কেউ নেই কোর্টে নিয়ে নিতে বলুন একজন কোর্টে প্যারেন্টস গুলো নিয়ে নিক
Item number 2.
Lordship, this is I'm in person appearing. This is for the restoration.
Have you anybody appearing for the state? Have you served upon the state?
Everything has been served twice. Before Mr. Senior Counsel Amitesh Banerjee was there, then after that his wife was there. He was all through presenting. And they've been served twice. The affidavit of service is also in the record. Last week also again
No, you were supposed to file a section 5 application.
This doesn't relate to that because this was done before 30 days my restoration. So that does not apply. That I think it was
to file supplementary. You were supposed to file a supplementary affidavit in respect of your section 5 application. Where is it?
Section 5 does not come into because I've already filed it before 30 days.
Section 5 to dekhiye.
If you see the page, my GA application.
Section 5 টা কোনটা? It when was it dismissed? When was it dismissed?
It was dismissed in September by Honorable Justice Rajeshra Bhardwaj. So the court order is there in the last page. The court none appears for the parties even after second call. No adjournment is dismissed for default.
And the orders would have earlier orders. And repetition order. আসলে কি করে হবে? Repetition earlier dismissal.
Been appearing all through. I have not done, but this somehow in last year it happened. Because the original side is taken only on Thursday. I never knew that as in person. And last time you said that you will restore this petition. And this relates to my property. Loan of the property.
September or 7th September, which within 30 days. ठीक है, शेड्यूलिंग फोटो Yes. Who is appearing for the state in this matter?
Mrs. Senior Counsel, Mrs. Amitesh Banerjee is appearing now. Before it was Senior Counsel Amitesh Banerjee.
Where is Mr. Akash Dotto over here? His name is appearing over here. Anybody for the state?
Last time Mrs. Amitesh Banerjee was there.
Mr. Akash Dotto, where is he? Just inform him to come. Let it be passed over. Ask him immediately to come. I'll just complete the list.
Lordship.
Item number 3.
Item number 3, I am for the state, my lord. But kindly permit me to appear on virtual mode, my lord, if you are permitted.
My lord, I do appear for the private respondents number 5
On the last occasion, lordship directed the Kalighat police station to submit a further report about the progress of the case. Now, my lord, my junior is before your lordship's court, my lord, she will hand over the further progress report. I need, my lord, for completion of the entire, my lord, investigation, another 1 month time, because entire document has been handed over to the, my lord, the authority concerned for verification of the document, the deed and the agreement.
Who is appearing for the petitioner?
Pawan Kumar Gupta is appearing for the petition, my lord. Since
Yes.
this is in courtroom number 238, my lord, I am praying for a short passover.
What is passover? He is wanting a 1 month's time to complete the investigation.
Okay, my lord. As per my lord's convenience.
Learned advocate for the petitioner is present.
My lord, in the meantime, subject to your lordship's permission, may I be permitted to submit something for a minute at least, my lord? My lord, if kindly comes to page number 17 of the writ petition, my lord, that is the prayer portion of the writ petition. My lord, kindly sees that the purpose of this particular writ petition, my lord, in my humble submission, has already been achieved. Therefore, my lord, this writ petition at this point of time, my lord, in my humble opinion, is not required to be kept open, my lord, in my humble opinion.
No, C is there, press C is there. They are wanting a progress of the case. Let them file the report on the next date. I'll close the writ petition.
Filing of this writ application, some
My lord
have been taken.
Acha, ki bola? Mr. Mukherjee, Mr. Mukherjee, learned advocate appearing for the state submits that another month is required by the investigating officer to arrive at their conclusion in respect of the documents which they have collected, as also verification of the same thereof. Good stuff. Learned advocate aid for the private respondent in Hmm. How many? 5, 6, both you are appearing?
My lord.
Private respondents submit that further pendency of the writ petition is unwarranted. Full stop. Since the state has sought for time to come up with a fresh report on the next date, I am of the view that the prayer of the state for taking the investigation to its logical conclusion be granted. Accordingly, it lists the writ petition under the same heading on 21st of May 2025 for further report.
My lord.
Madam, may I just request only one thing? Can it be 1 week after vacation, subject to, if possible? Because from 21st to I have some difficulty. If you like, don't take me otherwise, madam. Can you want just reopening the mallet?
I may not be available for 2 weeks after vacation. So there will be a long gap.
Petitioner is there. Petitioner, no, we are taking steps. Both parties are appearing before
No,
the
I
investigating officer.
understand, but the next date will be in July then. That will be a long gap. So let it be there. You pray. If you are not unable, pray for accommodation, I'll grant you.
But today, madam, I have filed the report. If you like, to keep with the record, madam.
Has filed a report?
My report has already been filed.
Report submitted on behalf of the state, aid be kept with the record.
Extremely grateful.
Next.
Item number 4.
Item number 4, my lord, I appear for the petitioner in this matter. It is that matter, my lord. It is that matter, my lord, which pertains to, my lord, an attack on the officials of the corporation and, my lord, the petitioner when they acted in compliance of the order passed by this honorable court. Now, my lord, on the last occasion, your lordship had directed the state authorities to produce the orders, my lord, how the private respondents had obtained bail from the Alipur court in a cognizable offense.
Yes, Mrs. Chakraborty.
My lord, I am sending.
So how has this happened? How do they walk in the court and get bail?
My lord, I am for the private respondent 6 to 14, my lord. Anticipatory bail had been applied for and it was granted, and thereafter the private respondent had surrendered, and thereafter the bail was and interim bail was granted, and finally the bail has been confirmed, my lord. That is the process, my lord.
Where did you get anticipatory bail from?
My lord, ACGM, learned ACGM.
Magistrate doesn't grant anticipatory bail.
Yes. The accused was. I have the surrender slip.
No, that's for bail. How did you get? From where did you get the anticipatory bail?
Additional Chief Judicial Magistrate.
How can magistrate grant you anticipatory bail? No powers are there.
Chief Judicial Magistrate surrender.
ওখানে নিয়ে নাকি এত তো লাগছে না প্লেট সাইডে এখানে পিকে পাঠান না গল্প পাঠান Have you got the? Have you submitted your report, Mrs. Chakraborty?
Last occasion, I have submitted my report.
No, today have you submitted a report regarding what I wanted to know? I have asked for all the order sheets.
My lord, I have sent the case diary to your lordship.
Your case diary.
It is clearly stating that how they got bail. আমার কাছে তো কেস ডায়েরিটা একটা ইয়ে নেই, কপি নেই তো। At the time of
In the case diary, I wanted the earlier order was state is directed to produce the case diary as well as all the order sheets relating to Nadia LPS case number 201.
But kindly provide me 7 days time. I will give all the order sheets, my lord. Can I?
You are the de facto complainant over there.
Yes, but I am the de facto complainant.
You raised objection over there. Your lawyer was present. I don't find any recording of the learned magistrate. I don't. First of all, no issue relating to anticipatory bail is reflected in the order sheet. Number one. Number two is that only appearance of the public prosecutor and the lawyer of the de facto complainant is recorded over there. Thirdly is that what is this type? Your PP was appearing over there, and it is required. It has been recorded over when custodial detention for the purpose of found to be not required. What is the seizure alleged weapon seized? What is the weapon which has been seized?
Furthermore, my lord, my lord may consider that only the respondent number 4 is, my lord, within the jurisdiction, against whom no relief has been sought for.
KMC is within the jurisdiction.
My lord, this is this is not the complainant, or nothing has been sought from KMC.
Who is appearing for the KMC? Your officials were assaulted. Yes or no?
Your lordship will kindly come to page 76, my lord. I have annexed a newspaper clippings, my lord.
Whatever may be the newspaper clippings, the statement of which are the statement of the officers appearing. Police
But I have submitted the earlier edition. So the 12:25, then the report signed by the officer.
What is the report sign?
State that Special Officer order in notice under section 412(1) has been served the concerned person responsible on 6 December 2024 during wall affixation of the apposite notice. 412(1). On April 2024, there was a gathering and agitation at the apposite premises by local people.
So KMC authorities were not assaulted. Yeah, I believe.
But I'm not. My instruction is that, and that has been reported in the newspaper below. I have been assaulted. My son has sustained leg injury. I have sustained injury.
That's a different that you have sustained, but you have said the KMC authorities were assaulted.
They were assaulted. Below. I was there
Where
on the.
there is no reflection over here in the
They,
KMC report.
But that is up to the KMC, my lord, whether they should lodge a complaint, my lord. But my instruction is that they were assaulted, and there was a huge gathering, my lord. And
Gathering and agitation was there. That's a separate issue. But whether the government officials were assaulted, yes or no? There is nothing on record.
Yes, nothing on record. But my instruction is that they have been assaulted, and there's a reflection to that effect in the newspaper next day.
So newspaper reportings we cannot use as a foundation of any case. They have their own mode and method of reporting.
But my apprehension is that the contempt is proceeding. There may be further action on the part of the corporation, and the corporation goes to demolish. Our property will be damaged, and we will be attacked.
What are you praying now? What are you praying now before this court?
But I am praying for some protection because there is a continuous threat on my life. One of my son is a medical student, but he cannot come home because of this incident. After this incident, you should exercise due caution, my lord. But when the corporation goes to demolish the structures,
my lord, in the petition
appearing in the list, it can be taken up anytime.
What is life and liberty?
My lord, in the petition, in this petition, what they are praying, my lord, kindly come to the prayer portion.
I have seen that. That is why I'm asking.
My lord, they are praying to directing the respondent police authority, particularly the respondent 2 and 3 herein, their main agents, servants, and subordinates, and each of them to show cause as to why they shall not be directed to take necessary steps in terms of the FIR being number 201 dated 11 December 24 and to protect the life and liberty of. So they are wanting stay over that FIR, my lord.
No, not a stay over this. Steps to be taken in connection with FIR.
Abstain.
Petitioner has. I'm disposing of petitioner. He has prayed before his court for taking necessary steps in terms of the FIR relating to Nadial PA's case number 201/24. So earlier, KMC has already submitted a report. Although there was submission that the KMC officials were assaulted, but none of the reports submitted by the KMC reflects the same. And the report of the KMC reflects that only there was a gathering and an agitation. Full stop. I have perused the case diary produced by the learned advocate appearing for the state and the steps taken. Prima facie materials have been collected by the investigating agency so far as the merits of the investigation are concerned. Full stop. The prayers presently advanced by the learned advocate appearing on behalf of the petitioner is relating to protection. Since the petitioner and his family members are the petitioner and her family members happen to be witnesses in the case already registered by Nadial police station. I direct that in case any application is advanced before the learning aid magistrate in CC of the Force Aid case, for necessary EA protection, learned magistrate by adhering to the provisions of Witness Protection Scheme 2018 would call for a threat perception report from the concerned police station and thereafter pass necessary EA directions, thereby ensuring the life and liberty of the petitioner and her family members. Full stop. So far as the other prayers are concerned relating to the bail granted to the accused persons, petitioner would be at liberty to take steps in accordance with law before the court having jurisdiction. Sure. With the aforesaid observations, WPO 1236 of 2024 is disposed of. Connected application, if any, is consequently disposed of. Case diary submitted aid by the on behalf of the state be returned to the learned advocate appearing on behalf of the state. Server question.
Item number 5.
Service complete. Thank you. Your service is complete. Sir, your service is complete. Who is appearing for the state? So let the state appear. You file afresh upon the state office of the government leader. In their absence, I can't pass an order. Use the microphone. Use the microphone properly.
The matter is very simple.
No, but somebody must appear for the state.
Then if somebody does not appear, Your Lordship, then I am here to get relief, Your Lordship. Simply, they are restraining my ingress and egress and not allowing me to put my name plate on the entrance door of my premises, Your Lordship. That is my simple prayer. I have become owner by virtue of the registered deed of conveyance. My vendor has already given me the possession letter also.
You send by speed post to the office of the government leader. That is not acceptable. Make hand service. Petitioner is directed to effect service upon the office of the government leader.
Government leader is not the proper party here. Original side advocate on record is Mr. Sinha. It has to be sent to the AOR's office. This is an order.
Service on the advocate on record of the state of West Bengal. Where is the office?
It is in Kiran Chandra Roy Road, Your Lordship.
At the office of the advocate on record. A fresh affidavit of service is be filed. List the writ petition on 21st of August 2025. Our opposing affidavit of service so file be kept with the record. Yes, sure.
Item number 6.
In this matter, I am appearing on behalf of the petitioner. When I have served all.
Me. Yes.
In this writ petition, I have challenged interdepartmental communication is in page 63. Now, this communication was relied in connection with the departmental proceedings by the respondent number 4. What happened in this case? Not before making any submissions, this writ petition can be disposed of without inviting any affidavits if subject to confirmation of my learned friend that is appearing on behalf of the other side. But in this case, what happened? Inter alia challenging this memo, interdepartmental letter, a writ petition was moved. In the pendency of the writ petition, a charge sheet was issued, and that charge sheet was also challenged. Both the
what are you challenging? What are
now
you
at
challenging?
present in page 63, letter dated 6th January 2023, by and under which the superintendent of SP of CBI has recommended for regular departmental action. It reports letter starts from page 63 and the recommendation in page 89.
But is this police in action?
Police, I moved.
It is a service matter.
No, I moved in the regular bench, but since it is a police election, the order has been set aside on this ground that it should be moved before the bench having determination to hear police in action matter by the division bench. Kindly see the order of the division bench in.
Show me. Page
106, my lord. It starts
106.
From operative part 112. Penultimate paragraph at page 112.
Yes. Yes.
In this
Alright.
case,
page 64.
Page 63 is the report which has been challenged in this writ petition on two grounds. First, the officer has no authority to recommend pass such type of recommendation for initiating departmental action. Secondly, the findings made in the report itself is incorrect. Kindly come to page 63.
What is the interim prayer?
There is no interim prayer.
So let them file their affidavits.
No, I have got preliminary objection to the maintainability. Because after page 63, a comprehensive charge sheet has been issued for violation of the discipline and appeal misconduct rules. And therefore, this is the specific finding of the division bench earlier, that in case of when a service matter is involved, that it has to be filed before the Central Administrative Tribunal under section 19 of the 1985 Administrative Tribunal Act. Kindly come to page 109. What is the observation of the division bench? Prior to that, kindly come to page 98.
No, that will be the final outcome when see over here, Mr. Chakraborty, this was my view also, what you are submitting.
I have not challenged the departmental proceedings in this.
Now you see over here, page 112.
No, your lordship has seen that division bench quashed all orders except this particular page 63. And it was under the impression the division bench, that since page 63 is under challenge, the notice of the CBI for the initiation of the departmental proceeding, it is a police matter. Because on the ground that the police matter, the learned judge who passed the order earlier had no jurisdiction to take up the CBI police matter. It was quashed. Now, pursuant to page 63, a comprehensive charge sheet has been issued by the departmental authorities.
So that you have got to submit.
An independent application of mind has been issued. The charge sheet does not disclose page 63 or the direction of the CBI. Therefore, since on a subsequent event, charge sheet has been issued, the entire thing has to be adjudicated before
The
the central
subsequent thing has to be brought on record by some way or the other, sir.
Page 98. Page 98.
In the earlier writ petition, both were challenged.
Page 63 has become academic. And charge sheet does not disclose that CBI has directed them. Their application of independent mind has been issued by the disciplinary authority.
Not correct. Kindly see page 99, article 1. The communication of the CBI should not be written in record, but he has no jurisdiction. Moreover, there is finding itself is wrong. Both were challenged. One part has been set aside by giving liberty to challenge before the CAT, Central Administrative Tribunal. We will do that. But relating to the communication of the CBI, we have been granted liberty to move it separately. It is their prayer. It was their prayer that the writ court had no jurisdiction on this ground. It is a police matter. It was the only ground prayer is a objection in the earlier proceedings. In the earlier proceeding, this record was also annexed.
No, we have taken the point
But
of
how a writ court can decide this, I don't understand also.
Exactly.
The communication of the CBI, it is without jurisdiction, he cannot say.
Whether communication CBI, whether CBI letter to be exhibited in the disciplinary proceeding, in the memorandum of charges, these are all matters to be adjudicated by the tribunal. After L. Chandrakumar's case, no matter can be adjudicated except by the tribunal under section 19. This is constitution.
I am not challenging the departmental proceedings. I am challenging the report of the CBI without jurisdiction.
So this has become infructuous in view of a issuance of charge sheet.
Oh, kindly during investigation,
The time of an illegal order is
one minute. How the report against the Shahan who is presently possessing it. Service of the How did you get a hold of this document, sir? Where was
they
it?
supplied? They supplied. In the earlier proceedings before the CAT, Central Administrative Tribunal, they supplied this document. And
so that
we challenged it in the writ petition.
Who challenged that in the writ petition?
My client. In the earlier writ petition, we challenged this communication.
So how can this be done? So this is
Kindly come to page 106. I'm sorry, 101. 101. Please kindly come to page 101. This communication, which has been challenged in this writ petition, was set aside by this Honorable High Court in writ petition being WPO number 1788 of 2023. That is in page 101.
But this entire judgment has been set aside by the appeal court. By the division bench. I have argued the matter.
No, this I understand, but then I am not bound by the single bench order. I am bound by the division bench order.
Exactly. And the division bench, kindly come to page 109. What is the observation of the division bench?
Yes, action may be initiated against them of this at your end. This action may be initiated against the above.
Central Civil Service Classification Control and Appeal Tools 1965.
So, even if I say this face of it, although What is wrong with this letter?
Now, first, the finding is incorrect. Second, he has no jurisdiction or power to recommend my employer to start a disciplinary proceedings.
No, we have not acted on these. These are matters of evidence. Your lordship knows in the departmental proceeding.
This should not be written in record. They have
are
acted
matters
very
of
well. Let it be set aside. Let it be set aside when they are not acting on.
Why shall it be set aside? One of the documents. Article in article memorandum.
And you are saying that you are not relying this or you have not been acting. Let it be set aside.
These are matters which are to be adjudicated in a departmental proceeding.
How
if
it
he
can
has any
be?
demands, he can
Letter of the CBI.
cross-examine. He can cross-examine.
One thing is this. One thing is this. This is a communication made by the Superintendent
CBI.
of Police, CBI, ACB, to
To
the
my-
additional directors and yes, your employer. Saying that materials have surfaced against him. So that a criminal, they have informed the department only. Whether the department will act on that, that is the department's discretion.
They first thing, this officer has no jurisdiction to write this. One thing, my lord, a case was started by the CBI against my client on the allegation of acquiring disproportionate asset.
Yes.
Inquiry was made. After exhausted inquiry, it has been found by the IO that the charge cannot be proved against my client. They filed the final report before the court, and court accepted the final report and dropped the case. And after that, what I don't know, who prompted him to write this letter to my employer?
No, when was it dropped?
But can you see the report is in page 23.
When was the case dropped and when was the
Prior to that, it was report was filed on 29th December 2022 by the IO. IO of the case filed report, that is in page 23. What prompted this officer to write this letter to my employer?
Lord, may I just submit only one thing, only basic question of jurisprudence. That the criminal trial, beyond all reasonable doubt, a case has to be proved. That does not operate as embargo or preclude us from initiating a disciplinary proceeding which is simpliciter on preponderance of probabilities. Therefore, he has no case, even if he is acquitted in a criminal trial. I have a right under a statute to
I am
initiate.
challenging the communication in page 63.
That is
There has no relevance with the departmental proceedings.
No. Page 63 has no function now. It has become infructuous.
Then let it be set aside. Let it be closed.
Why shall it be set aside? One of the documents in the charge sheet.
Tell me 4/7/2023 has been set aside.
Yes.
Huh?
Pardon, my lord. Yes.
4/7/2023 order page 59 set aside.
Yes, ma'am.
Page 59.
Yes.
Yes, my lord.
So if it is set aside, why are you bothered about this one? I don't understand.
They have again on the, after relying this, can you see page, that is my pen. After page
98.
4/7/2020.
It has been set aside.
So that included the 6/1/2023 communication also?
No, it was not dealt with in the earlier departmental proceedings. No. See, 98.
Page 97 is relevant.
Page, can you see the page 99?
Last paragraph of page 97.
90, yes, sir. Which page are you saying? 90?
97. Last paragraph, page 97. In view of the above, the punishment orders issued by the disciplinary authority, vigil letter number such and such, and the order of the appellate authority upholding the decision of the disciplinary authority, was the applicant is set aside. Respondents are at liberty to take further action in the matter in accordance with law. That is what is exactly recorded by the division bench.
Now it is there in accordance with law to procure a letter from officer of CBI
Is it
departmental proceedings.
for him to challenge the charge sheet?
Letter.
This
On
is
the
the
basis of the
challenge
letter in page 63.
How can I quash this letter? I don't understand. What is your prayer?
And first thing, the recommendation made by this officer is without jurisdiction. He has no right or jurisdiction to make a recommendation to my employer. To
Where
start
is the recommendation?
Yes, Malad. Page 89.
89.
Page 89. Last page of the report. Not last page. Yes. Now, Superintendent of Police, CBI, is recommending. I don't know on what basis he wrote this. Who prompted him to write this? He's malafide him. Two higher officers.
So whether it is bona fide or bona fide, that shall be decided in a disciplinary proceeding and thereafter in appeal, departmental appeal, division
It will
review.
be decided in disciplinary proceeding.
Or he can challenge the charge sheet before the Central Administrative Tribunal.
This letter. Kindly pass that order. This letter will be also I will be at liberty to challenge this also before the Central Administrative Tribunal.
Yes.
Oh yes. Agreed order. Kindly pass this order and dispose of the writ petition.
No, how the letter can be challenged before the Central Administrative Tribunal?
Very fine.
It does not come within the definition of service matter under 85 Act.
The same in the court in excess.
No, contradictory statement.
What contradictory statement? You are trying to get at something in an indirect way, which you cannot do under a direct way.
Yeah, for explained by her before the defining.
Page 89.
Explained by her.
Kindly,
Sir, one thing is this, try to appreciate one thing. Acha, Mr. Chakraborty.
Yes, my lord.
You show me the law where you can recommend for this thing, page 89. You are doing a criminal investigation. And in the criminal investigation, you found something. According to Agnihotri's case, you came to the conclusion, since this 10% is the flexible limit given by the Supreme Court, it is not possible for you, since this is an extra amount which is not coming, which is coming within that limit. Now, for that, you are not doing the criminal case. It's all right, agreed and accepted. But where from do CBI get the authority to pass this one, that although criminal case is not made out according, where from this major penalty recommendation has been done?
Kindly appreciate only one thing. The recommendation simpliciter on at page 63 has no bearing because of the fact that after expiry of 10 months, the disciplinary authority
Very good. You should, all right, I will consider that. Show me the law that the CBI, because this has been done. This has been done by the Superintendent of Police, CBI, ACB, under your rules, either under Delhi Special Police Establishment Act or the guidelines you follow. You show me that CBI has got the power to make this recommendation.
With great respect, I submit that had this letter not been issued at all, whether we had a right to initiate disciplinary proceeding, which is to be proved on preponderance of probability, even if in a criminal trial some acquittal is passed, order of
No, this you are doing, you show me the law. I'm keeping this matter pending without passing any order. You only these two extent, because this I have been seeing for a long time. There must be a law, either under your guidelines or rules, because this is not in the DSP, not in the CRPC or the BNSS.
This is in the service jurisprudence. This is available. That even if there is an acquittal in the criminal trial,
that is a principle. That's a principle. Acquittal of in a criminal case do not absolve the person from facing departmental proceeding.
Yes.
That's a principle. But then they did in the chart. This is the chart sheet. In the chart sheet, how can you write this?
No, charge sheet, page 98. Kindly say once again. Page 98.
This is charge sheet, sir.
No, charge sheet does not start with the recommendation at page 63. It is an independent application of mine. What is the charge? Memorandum. The undersigned proposes to hold an inquiry against Snehasi's court, health administrative assistant posted at such and such witness counter.
So, sir, this was not there prior to 6/1/2023.
Not there. Yes.
So that's why I'm asking, sir. You were recommending, Department Suomoto would have done something, but if it is done after 6/1/2023, there is a clear nexus between the charge sheet which has been submitted, where you come to the conclusion. Therefore, CBI will be all the CBI witnesses will be there in the departmental proceedings. This is your finding.
This is Annexure 3 to the charge memorandum.
I'm coming. Kindly come to page 88 and 89.
Yes.
88, you see the bottom paragraph. Whatever you have calculated relied upon Agnihotri's case. Then said that since 10% is the limit given over there, and you have got the percentage of DAA is about 19%, including so and so, and rupees so and so as value of inventory in the total disproportionate amount, which are gray area, and this amount would not be possible to conclusively prove. So you are coming to your conclusion so far as the criminal case is concerned under the Prevention of Corruption Act. Now, it's all right, sir. You could have stopped over there. This is a report under section 173 or 193, whatever it is. Now, this power you additionally ask for consideration. This, see over here, next page 89.
Yes, major penalty recommendation is there on the right hand side.
You understand?
Now, may I just only submit one point? This recommendation, like the CBI or the recommendation of the Vigilance Commission for initiation of a disciplinary proceeding, whether this can at the prima facie level, presumption can be drawn that the initiation of disciplinary proceeding is malified, because
I will not, sir. I am not touching anything. I am not touching the disciplinary proceedings also. I'm just asking you, as a part of the report which you are submitting in a criminal proceeding, you have a power, because see, under the Prevention of Corruption Act, this act was brought into force. If we go to the original one, in the this is 1988, earlier was 1947 Act. The act was brought into force for monitoring the public servants concerned, and to see that without for discharging their duties, they are not making disproportionate assets. That was there in the 1947 Act itself. Thereafter, subsequently, 2 amendments have been brought in 1988, again in 2018. And the Delhi Special Police Force was established at the relevant point of time only for the purpose of the central government employees working at Delhi for investigating and monitoring them so that they are unable to make disproportionate assets. That's in the object of the 1947 Act, you'll find, and the purpose for establishment of the DSP. Now, with passage of time, there has been extensions. I don't dispute that. Now you show me from the powers over there, irrespective of the disciplinary proceedings, sir, that within the charge sheet itself you have from which rule, because this is being done regularly, under which rule you are there must be something, otherwise why are you doing that? Show me that rule, that where from are you making this recommendation, whether you come to a finding that a criminal case, because see, this is not today. If you remember that Rizwanur Rahman's case, the person died in the railway tracks. There were 4 to 5 police officers. I was in that case. Now, in respect of 1 or 2 police officers, substantial offences under the Indian Penal Code charge sheet was filed. And in respect of 2 to 3 officers, this departmental proceeding was recommended. There was no corruption case, but since that was a High Court order, so where from are you getting this power for informing the department to take action against his person when you are not coming to a conclusion that the criminal offense is made out?
Kindly appreciate only one.
Yes.
Even if this recommendation is without jurisdiction, whether we have as a disciplinary proceeding authority any power to initiate proceeding on the ground of misconduct.
Who are appearing for whom? CBI or the health department?
Health.
Mr. Amarjit, they will answer this.
I don't have any instruction, just your
You come with that instruction. Because
pleasure to give direction, short direction for affidavit, which actually fell from my lord at the initial stage.
No, that will be too long taking. See, first I was reluctant to take up this matter only because the Honorable Division Bench has said that this will fall under this writ petition police inaction matters. I am taking up the matter. But they have taken. Otherwise, now I am within a campus. Earlier, I was under the service matter basically, nothing to do. Now they have come up, and once that has been said, I will deal to the point that whether CBI had the power to make this recommendation or not. Nothing more than that. Even if that is not there, you are entitled to carry on a disciplinary proceeding, sir. That also I agree.
Would it be Lordship's pleasure to give us short direction for filing affidavit? We shall disclose everything.
But you are held.
We shall disclose. Now, second point, with great respect, I submit. Even if your Lordship holds that page 63 is without jurisdiction and malafied, your Lordship now cannot quash the charge sheet because this falls within the service jurisdiction.
No, I cannot, sir. That I understand. But the thing is that also. Malafide I don't find, sir. Where is the malafide? Without authority it can be.
There matter which is sought to be agitated before your Lordship should have been or ought to have been agitated before the Central Administrative Tribunal, pursuant to the leave granted by the Division Bench and earlier CAT's order.
So why are you wanting to file affidavits? Let them file a report where from they are got that only. Let CBI file a report only. Why are you lengthening it, sir?
One thing, I have one prayer, my lord.
Yes.
But also direct them to disclose why this letter has been issued, on what basis.
Letter will
not part of the criminal investigation, not part of the criminal case. This letter.
This will come. No, that will come. That will come. This recommendation, if they have authority, that will automatically come. If they have the, because this they are doing in many cases. This is not the only case I am finding. There must be, if there is any rule where they can recommend that. Rule, government, memorandum, whatever document CBI has, just by way of a report file this. You understand, Mr. Dey?
Possibly, Munnar, this is available in the CBI manual.
Maybe. I don't, but this is being continuously done actually. It's not the only one case I am getting. Acha, petitioner is aggrieved by certain communications made by the CBI, including the recommendation which has been made by the Central Bureau of Investigation to the this is what Central Government Health 63 years. To the Additional Director, Central Government Health Services, Health Scheme. Full stop. Mr. Learned ASG is appearing on behalf of the
Respondent number 1 and 4.
Respondent number 1 and 4 submits that independent of the recommendations of the CBI, charge sheet has been submitted, and the recommendation of the CBI or the communications which are the basis for invoking the jurisdiction of the court under Article 226 of the Constitution of India.
One is appearing on behalf of the respondent number 1 and 4 submits that independent of the recommendation of the CBI, charge sheets have been submitted, and the recommendation of the CBI or the communication which are the basis for communication and for invoking the jurisdiction of the court under Article 226 of
is redundant at this stage.
But in this matter, I have twofold challenge. One is without jurisdiction, and another, the report itself is not correct.
I'm not entering into that zone. For that, I have got to call for affidavits. I am not entering that zone, provided CBI is able to satisfy me or dissatisfy me. Let them. Mr. De Lane, Aid Special Public Prosecutor, appears for the CBI. He is directed aid to submit the relevant laws from which CBI derive the power to make such recommendation in the these are 173 report basically, Mr. De. This is your final report basically. This is the report under 173. Tati kore in the report under section on 173 of the CRPC. Acha.
Which report, page 63?
No, 63 is not the main thing, sir. 60, 65 onwards, what their CBI report. 65 ends at 89, na?
Yes. 63, practically, it is the annexure of the...
Whatever, 65 is the report, basically.
Yes, yes.
CBI derives their power to make such recommendation in the report under section 173 of the CRPC.
Let a report be submitted by the CBI through Mr. Dale and his Special Public Prosecutor on 21st of May 2025, when the writ petition will appear under the same heading. Let them file that. Thereafter, if required, affidavits I will require. Whatever is it. Copy of the petition, writ petition.
Already served, my lord. I have already filed my affidavit of service.
I mean, you are served at the office. Please give him a copy. Please give him a copy.
No, on the next occasion, kindly will also consider all points which are now being thrust in the writ petition. These are subject matter of reply to the charge sheet under the discipline and appeal rules for holding disciplinary proceeding. In reply to the charge sheet, he should have agitated this question.
Yeah, but this is also a part actually. Under CRPC, there is nothing like this where you can bring. But if there is in the manual of the, because CBI proceeds according to the manual. Manual has been approved in Vinit Narayan case to be the mode how to be acted. So if it is available in the manual itself, I will accept that also, sir. কি বললাম ওই 21 মে একই জিনিস সব করে evidence service file kept in the record.
Audit part.
No, not audit part. I'll be there the HMA পর্যন্ত আছি হ্যাঁ under the same heading করলেন নাকি আবার মারপিট করবে under the heading for orders করে দিন কিছু 21st of May for orders, right?
Fair oblige, madam.
Item number 7.
Madam, I beg to appear on behalf of the state respondent in this matter.
Petitioner.
Item number 7, I am for the private respondent. It is served to us without the WPOP number, Your Lordship, and has suddenly appeared in the list. Your Lordship would adjourn the matter for the day and allow us to file our objections as well.
Madam, I am ready with my instruction, madam.
There are a lot of facts which have been. Lordship, the court has been.
That order be passed again.
Not many documents which is need to be forwarded.
Case registered or no case required to be registered? State.
My lord, we have taken all initiative, my lord. First of all, my lord, this is a take a property, my lord. The petitioner, they preferred a title suit before the city civil court, my lord. Ultimately, that has been dismissed, my lord. Now, my lord, upon the complaint, my lord, in the month of April 2024, we have lost 2 FIR, my lord. One against the respondent, private respondent, one against the petitioner, my lord. Case and counter case, my lord. Both resulted in charge sheet, my lord. Thereafter, my lord, may I submit, my lord?
Yes, you carry on.
My lord, may I submit, my lord?
Carry on, yes, please.
Now, my lord, in the month of September, my lord, another FIR has been lodged against the private respondent and his wife, my lord. That has also been resulted in charge sheet, my lord. This is a family dispute in between 2 brothers, my lord. And since it is a civil in nature, my lord, we have taken all these steps and charge sheet has subsequently, the charge sheet has also been filed, my lord.
September, which year?
My lord, September 2024, my lord. The 3rd FIR, my lord.
Lordship, it is 23.
And you are making a 23 complaint now after so many cases have been registered. The
Lordship, a
foundation
forgery case is pending against him himself.
Foundation of the writ petition go before the learned magistrate.
My lord, this is a civil in nature, my lord. Family dispute, my lord.
Nothing to see, sir. 1.5 years have passed. Go to the learned magistrate. Magistrate will call for a report and take it.
Oblige, my lord.
No exceptional circumstances for invoking Article 226. So, petitioner is aggrieved by the fact that his communication to the officer in charge, Calcutta police station, were not acted upon.
Police hands in glove with the
Lordship, there is a forgery case filed against him.
My lord, we have filed charge sheet. If they are aggrieved by my lord.
Records reflect that
not against this private respondent, who is the main
information was furnished with the police station on 29th of August 2023. Full stop. Petitioner submits that in spite of different cases being registered at the behest of the police authorities, but till date, so far as the accusations made in the information furnished on 29/8/2023, no case has been registered. Full stop. Learned advocate for the state has submitted that the genesis of the facts relating to the dispute arose from differences amongst the family members, for which series of criminal cases have been registered either against the petitioner or against the private respondent. Full stop. Since the Calcutta police station is well aware regarding the nature of the dispute and difference between the petitioner and the private respondent, at this belated stage, after our चार আর এদিকে চার 4 আর 3 7 after 1 year 7 months I do not feel it necessary to interfere with the nature of dispute complaint of. However, petitioner would be at liberty to canvass the issue before the learning magistrate, learned jurisdictional magistrate by way of invoking the provisions of section 175(3) of the BNSS oblique section 156(3) of the CRPC full stop. Learned magistrate would assess whether any cognizable offense is made out, comma, ascertain whether the case for investigation has been made out, and also call for a report relating to the nature of the previous cases pending between the parties, and thereafter exercise his discretion in accordance with the provisions of law. Full stop. Learned advocate for the private respondent submits, since no affidavits have been called for, the accusations and the allegations made in the writ petitions are deemed not to have been admitted. Acha. In view of the last slide, in view of the observations made above, no further directions are warranted. Full stop. Next, accordingly, AWPO 246/25 is disposed of, server copies.
My report may be kept in record, my lord.
Report patheche. Report submitted aid on behalf of the state be kept in the record.
Highly obliged, my lord. Highly obliged.
Pass over to Dakuna.
Item number 2.
Item number.
Yes, Mr. Otto, what happened?
Sir, I just again mismanaged, I suppose.
Huh?
In this matter.
So somebody must be appearing for the state. I find your name is there.
Yes, sir. I will take necessary instruction. Last occasion, there is a direction for filing supplementary affidavit. I'll check.
But that is not required. Actually, he pointed out correctly. That was at the borderline date. The last date he filed the restoration application. So, should I restore the application? You are not engaged officially.
Not engaged officially.
Sir, please restore the. So you had promised.
I can restore, but nothing will. Restoration I can do, but a state advocate, he is not officially engaged.
There's a lot of corruption and all. Then it will continue the matter. Please
continue on the same date. I continue on the same. You come back on 21st, sir. Can't do it. You get an official, should I say? But then Mr. Sinha is the advocate on record. But can I? Appellate side, it is easy to make.
The most senior solicitor, Sinha and company is there for the state. Everybody knows that, sir.
Mr. Datta, I'm recording your name. You seek an official, by showing this order, seek an official appointment and be present on the next date.
They have done so much of harm to us, sir, last 60 years. We cannot expect that, sir, if I give a list of it.
Acha, petitioner in person is present in court. Although Mr. Akash Dotto's name appear in the earlier order sheets, but learned advocate submits that he appeared in the matter as there were certain changes in the government panel. Full stop. Since Mr. Dotto was appearing in this matter, he may be officially engaged. As per he may be officially engaged by the concerned authorities. Full stop. Let steps be taken by the state in this regard. List the writ petition on 21st of March 2025 under the same heading. Show these, get your appointment and instruction, sir. Nothing
grateful, Lordship.
I will.
Next.
Item number 8.
Hearing also, Boro.
But the CBI was directed to file a preliminary inquiry report. I did not appear.
Order sheetটা দেখি আগে একটু আর একটু উন্নত কি মামলা করে বুকসাতে একটা বড় নেটওয়ার্ক একটা As the petitioner already informed the joint legal and then is already made. Where is Punjab? Yes, madam, एक तो इस report. We submitted this report in the preliminary findings 363. Gallo, our time chalo. How much time you require, Mr. Day?
I have the report.
Huh?
I have the report.
That's the earlier report is with me. The same report. This report is dated 10/1/2025.
No, Lordship, this is a subsequent.
Subsequent report.
2025.
Ah. Have you concluded the preliminary inquiry?
That's it.
এই একটু আনুন না ওই রিপোর্টটা দিচ্ছি ঠনতে হবে
May I be handed over a copy? Because
let me see.
And from 8 onwards.
Yes, sir. You have filed a title suit.
Title suit challenging the lease deed,
Ah.
which was executed violating an earlier order or decree passed by a civil court. There was a
Where do you stay actually?
53 by 2A.
No, you don't stay over there.
But I stay over there, 53 by 2A. That is the address, my lord. Even in the affidavit.
You don't stay over there.
My lord, kindly see page 21. Voter ID.
अरे voter ID होते पारे. You don't stay over there.
Even in the
neither your phone number is working.
How can that go? I am in touch with client in that phone number, my lord.
CBI has gone to your home, did not find you. CBI tried to ring you, you did not respond.
Can I come back with instruction to the defect? Because my lord, I have been in touch with the client, the petitioner. My lord, over that same telephone number, my lord, he has been instructed. He has instructed.
On which phone number do you ring him?
Nine 933
Sorry, this number is not the number.
And one more number 86488.
In this number, CBI called you up. You did not respond.
32 numbers.
The next number, first number, I did not agree. This number is appearing in the report, but you did not respond to the CBI's call.
Lord, please, their concern. May I come back with instruction? May I ask the petitioner to be present for this?
So what I will do with this physical, I cannot hold a trial. I am a 226 court.
My lord, with regard to the allegations, all are document based.
All are document based. You go to the court below, sir. CBI has come to its finding.
With regard to kindly sees what the allegations were. So civil should regard to the deed that was executed, but the subleases were executed without any title, and those properties have been mortgaged. The deeds, sublease deeds have been mortgaged. Well, only one lease.
Again, so, very good. Who were the persons who did that?
But the mortgagees, they are not traceable. They are just
Forget about that, sir. Prior to that, who were the persons who did that? Those were your relations?
But the persons who executed the lease.
Shunil Devhovik is available.
Yes, my lord. They are available. They are available.
They are dead. Sunil Devhovik and Chandan Devhovik is dead.
But then how come this deed was executed? Well, this was
after that, this is what is. They executed that in favor of that Jaiswal. That went to Naman, sublease.
That is the kindly sees the page 60, schedule of the lease deed. One property was leased and two properties were subleased. But one property was leased by showing the same deed, two separate premises were sublet. That could not have been. And the deeds of the two sublease deeds were mortgaged with the bank and loan was taken.
Who did that? Who are the signatories in that lease deed?
Look, page 60. Chandra Devomik and Sadhana Devomik.
Who is alive? Sadhana is alive.
No, Lord. Sadhana expired on 2000.
Why are you answering? Let him answer.
I'm sorry.
Lord, this Sadhana did not obtain the money from the bank. This Jaiswal did.
Did, because Sadhana, who parted with the property? Sadhana.
Lord, Sadhana parted with the property. Kindly see page 60, Lord, what Sadhana parted with. Kindly see for a moment. 405 square feet at 53 by 4C. And what was mortgaged to the bank? And what was the subdeed? Kindly takes page 73 and page 89 of the other two deeds. Page 73 once. 431 square feet at 53 by 4B, citing the deed number, same deed number. Lease was obtained with regard to 405 square feet flat at 53 by 4C. And a sublease is being done, citing that deed with regard to 431 square feet at 53 by 4B, which was not even transferred by virtue of that lease deed. How we could have, because the deed that is being cited is the mother deed. Only one lease deed is being cited, and sub-leases are created in respect of different properties.
How did you file your case? Because see, you have already filed a civil court case.
Not regarding this, I have filed the case challenging Sadhana Devogni's transfer because that is in violation of preemption. And subsequent to that transfer, these sublease were executed, and the person who got this property by virtue of sublease has now eloped with the money by mortgaging the property with the bank. Now there is no title at all with regard to these properties. Now we have shareholding in these properties. We are fighting out before the suit court with regard to the lease, original lease. But with the interest of the bank, the public money involved, public money they have taken and they have gone out. Now, even if we succeed in the suit, there is a charge created over the property by the bank because of the mortgage. Now, we are not at fault. We do not have anything to say. We have taken every step possible as per law. Now,
No, that you have got a right over the property that you have got to establish before the civil court first.
That is pending. But
pending that, what bank steps will take. This is a bank's discretion.
Have already filed before DRT. We are going to proceed as per surface so far as the NPA account holder is concerned. Sucheta Jaiswal. We would proceed.
How could the mortgage this property? How could they accept the mortgage of a property which the mortgagor has no title?
Because the sublease was mortgaged with us. Sublease agreements.
Sublease agreement by virtue of a deed which does not exist.
In 1970, how do I stand?
This property was never leased. 53/4.
It also was not because of that. It was for a different cause of action altogether. Some persons were doing some construction that was police did not arrest. That was the cause of action. No averment has been made in the so far as the bank is concerned in the writ.
No, there are averments. There are specific averments.
No, relief has been claimed in the writ.
How can I claim relief against the bank? I'm praying for investigation. How can I claim relief against the bank?
Yes, on the basis of that. Lordship, prayer F, page 19. On the basis of that prayer, CBI has investigated and submitted a report before you.
So may I get a copy of the report and come back to that effect? Because what are their findings with regard to this? Because my specific grievance is this 53/4C was not a part of the transfer, and this has been mortgaged, and public money is being taken by mortgaging this, and the bank is not even verifying the titles.
Which year this mortgage took place with Punjab National Bank?
My lord, the property mortgage to the bank was at 53/4B.
No, which year? Which year?
1970, 3/4/1970. How am I going to say what happened then?
The deeds are of 2006. The lease deeds.
You come now. Why?
The lease because I get to know now.
After 50 years.
No, my kindly sees the lease. Whatever the bank is submitting, kindly takes page 48. The execution is done in 2006 and there's a mortgage.
I know you are suffering, but I know there's no issue related.
No, not that. With regard to the submission, that this.
I understand, sir. There is a case, but there is another principle. No, delay defeats justice.
But I have not delayed. Kindly takes page 48. Look, this stamp paper, the deed, the lease was original lease was executed in the year 2006.
That is the sublease part.
No, lease part. Look, the lease kindly sees the date of lease. Page 40 kindly takes the date of execution.
Jaiswal, he had taken the lease in again 2006. From Ashok Kumar Jaiswal, this is transferred to Sucheta Jaiswal.
How can the mortgage be 70 then?
Became NPA, and we have proceeded as per SRPC against the NPA.
Well, the lease is being executed in the year 2006, and how can there be an
further executed in 2009?
It must be thereafter. Then how can
I have the copies of the sublease agreements, my lord.
But how can the property be mortgaged in 1970 then? The sublease is the
sublease আমার কাছে আছে
কোন সালে mortgage to the 73 crores. 1970, how is this possible? It's totally contradictory submissions by the bank.
It's clearly contradictory that.
Report is with respect to the criminality committed or not, whether the investigation is necessary or not.
investigating agency has submitted the report. Let us go by the report then. That is all right.
You filed 175(3), nothing can be done right now.
May I get a copy of the report and come back? Well, at least let me verify what they have. Well, these are documented. I cannot change my case. What are their findings? Let me get to know that at least one opportunity may be given. 2 days time. I'll come back on the next operative day. Because what they are relying upon, I do not know. My case is on the basis of documents that's before your lordship.
This is not spoiling your case, sir. You get a direction because this is between the court and the CBI.
They say
this is not a finding. There's a whole lot of documents over here.
May I just come back with this report? Kindly give me one opportunity to at least go through the report. What are their
you have a case being made outside. No, don't dispute that. You have a case, but not for the CBI. CBI, I am not agreeing completely with the CBI's finding because this is a dispute. Nature of dispute as complained of. Bank is assured of its property.
No, subject to lordship's correction, bank is not because there is no title. Bank cannot claim because once and for all, in one forum or other forum, bank has to lose because they do not have title over 53/4C because that was never parted with. So they will lose.
That is your claim, sir. That is your claim to prove that. To prove that before a court of law is primarily your duty.
My lord, I can. My lord, kindly see. I have shown to your lordship these schedules.
It's not my duty, sir. My duty is to see whether police was inactive or not.
Nothing was done. Police did not do anything.
Sir, police has come to a court. You want a FIR to be registered by the CBI? That is your main why you have come over here. CBI has come to a conclusion that a FIR is not required to be filed in this case. So ordinarily what happens, sir?
Supplied, and I can file Narazi if this is before the court, magistrate or the special court. I will have the option of filing Narazi if there is an FIR and if they file closure report.
And if there is no FIR?
But I can challenge this before.
You have got to file a 175(3), sir. That is what I am granting you. What more can I do? I'm not saying.
But a copy of the report may be handed over.
Copy of the report cannot be allowed to be used, sir. This is a difficulty.
For peruser, I will not. Well, that cannot be evidence because that is against me. I cannot use that.
No, any of the party can use that, sir. Now you will come and say the officer did not ring me. I was available this time. Then on ground, these are all multiplicity of useless litigations in the original side.
Allow me to go through the report because on what ground they are saying.
Second report you share with the parties. Second report, Mr. Day. They have conducted a preliminary, come to a conclusion. Petitioner has approached the court being aggrieved by the inaction of the representation made to the Joint Director CBI on or about 19/9/2024 against officers of the bank and certain individuals. Petitioner's main thrust of contention was that the money was granted aid on collateral securities which were shown to the bank on which were submitted to the bank on the basis of forged and fabricated documents. Pursuant to the writ petition being filed, CBI was directed to conduct a preliminary inquiry. Consequently, the CBI conducted an inquiry after registering PERR number PE 0102025 capital A 0001 and under the covering of DIG and head of the branch CBI ACB. Earlier report was submitted. Today, the Superintendent of Police CBI ACB Kolkata has submitted a report according to which no criminality and irregularities were found. Full stop. Learned advocate aid for the Punjab National Bank. Respondent number 5. What are you?
Five, my lord.
Respondent number 5 is present and submits that the bank has already proceeded to take steps in accordance with law before the tribunal. Full stop. Mr. D. Lander Advocate, Mr. D. Lander, a special public prosecutor appearing for the CBI, has submitted the report. Let the same be kept with the record, and the findings as recorded above reflects that the CBI, on the basis of the materials which they have collected, as also the witnesses they have examined in course of the inquiry, do not feel it deemed proper for registration of a criminal case. Full stop. Consequently, the petitioner is left with the only alternative to initiate a proceeding before the jurisdictional court if so advised under the relevant provisions of section 175 3 175-3 BNSS. In case such an application is filed, learned magistrate would assess whether any cognizable offense is made out, ascertain whether there is a necessity and scope of investigation, and consequently pass necessary directions in accordance with law by exercising his discretion. Sure. With the aforesaid observations, WPO 1084 of 2024 is disposed of. Reports are submitted by the CBI be kept with the record. A copy of the report be handed over to learned advocate appearing on behalf of the petitioner.
Kindly mention the report dated 6th of February 2020.
Report dated 6th of February.
Gratefully, Lord.
একবেলা কেটে গেল বুঝছি আমার এখন 9টা
Item number 9.
হনুমান জয়ন্তী ম্যাটার আছে
My lord, will you taking up the supplementary list, my lord?
wait.
My lord, item number 9, my lord, I appear for the petitioner. My
Yes.
lord, this is a KMC assessment matter, my lord. Perhaps, my lord, this is wrongly appeared. Yes, my lord.
Learned advocate, এটা কত 9 নম্বর learned advocate appearing on behalf of the এটা কোথায় গ্রুপ 9 নয় কি মেনশন করে দিয়েছে
It's a group 5 matter, my lord.
Group 5, learned advocate appearing on behalf of the petitioner submits that the subject matter relates to a different classification. Accordingly, let the petition go out of list, and go out of list. A petitioner would be at liberty to mention the matter before the appropriate court.
I'm grateful.
Next.
Item number 10.
But 10 on the last location, there is a direction upon the state to file an opposition. Number, although I took a preliminary point regarding maintainability of the writ petition in the appellate side, in the original side, because all the respondents are in appellate side. But however, my lord, kindly extend the time for 2 weeks, my lord. I will file, although I can argue, my lord, without affidavit that unless there is an order passed by under section 14 of the SARFAESI Act, police can't help the bank to recover the car. There is no such order.
Learned advocate appearing for the state praise for 2 weeks accommodation to file affidavit in opposition. Let the affidavit in opposition be filed by 38 April 2025. Affidavit in reply, if any, be filed by 15th of May 2025. Exchange of affidavit should be completed by 16th of May 2025. Matter be listed, a petition be listed under the say A meeting on 21st of May 2025.
Yes, Your Lordship.
Item number 11.
কোথায় ওরা? আর এসছি তো, লোকনাথ এসছি তো, কি হলো? None appears for the petitioner.
Yes, my lord. My lord, may if my lord sent, my lord, for the last 3 occasions they've taken time.
You have been successfully able to frustrate them actually.
My lord,
None appears on behalf of the plaintiff public petitioner. Learned advocate for or the defendant is present. The Election Commission of India is also represented by the learned advocate. In view of the petitioner being absent, list the election petition.
last
Yeah,
time
understand.
to indicate, my lord, let it be sent to the month list of October.
No. On 21st, appear once in 1.5 months. We'll see you 21st of May 2025. Just before the vacations, one day.
But after vacations, man.
After vacation, I will keep before the pujas.
My lord, then month list of June.
ওই মেতে আছে একবার করে দেবে। ইলেকশন পিটিশন কিন্তু ওটারই হ্যাঁ। ও আচ্ছা ঠিক আছে। যাই। Yes, sir. Next, appellate side के पार्टी से हाँ। I'm there. Don't worry, I'm there. I'll take the hearing. Thereafter, I will take up an fixed matter. Thereafter, all those Hanuman Jayanti and urgent matters. Okay. क्या है? फाइल কোথায় নাম ফাইল তিনটে ফাইল অনেক সময় পেয়ে গেছি Yes, Mr. Dotto, where is he? All right. Let me take a then 5 minutes break. 5 minutes, I'm coming back. Ask him to go. 8 o'clock. কোর্টে দিয়ে দিতে বলো।
কোর্ট রেডি করা আছে, আমি বলে এলাম কোর্টে গিয়ে। 3 PM fixed matter, item number 4.
আর অন্য কাগজগুলো কোথায় গেল?
এটা হচ্ছে
কিশোর দত্ত করতে হবে। কোনটা?
ওটা ওইটাই সাহেব, এটা পিটিশন।
ঠিক আছে।
এটা
একটা এই বের করে একটু। Mr. Dotto, in this matter,
Yes, sir.
you have already relied upon Hitesh Sharma, Sube Singh, then over there at Shamsundar Trivedi.
Singh also I have referred.
Alec Padamsi.
Alec Padamsi, unreported Sirajul Islam Gharami.
Imtiaz Ahmed's case, Ashok Kumar Nath, and Sirajul Islam Gharami. These are the cases you have relied upon. These are the documents which are with me, I mean judgments, and the report which you have submitted.
Yes, sir.
Along with that, subsequently, I believe you have come up with this one. This judgment is what? Anita Kushwa's judgment, paragraph 29, you have relied upon.
Yes, sir. This is on access to justice. You know, this was Millard, your lordship's query. Therefore, Millard, I had placed paragraphs 29 to 40 of this Anita Kushwa.
Yes.
Then Millard, 3 judgments I have placed, not in this matter, but in the other matter.
Yes, other matter you have placed those judgments.
And Millard, I have requested your lordship to treat those 3 judgments cited in the other matter to be cited in this matter as well. Where the principle over there is that if a point of law is ostensibly emanating from a point of fact or issues of fact, then it has to be in a writ court, it has to be pleaded in the writ petition, supported by evidence.
That Bharat Singh's case.
Okay, Bharat Singh's case. Those 3 judgments I have cited in the other matter. Your lordship may kindly note down here the citations, if you possibly it's not with your lordship in this file. Bharat Singh is 1988, volume 4. Supreme Court cases 534, paragraph 13, 1-3.
1-3.
Then 2019, volume 11, Supreme Court cases, page 1, para 199.
There is Sabarimala judgment.
Sabarimala. And the third one was 2010, volume 12, Supreme Court cases, 609, para 15.
That's a reiteration of this Bharat Singh's judgment.
Yes, simply. There are other judgments also, just 2 or 3 minutes I had cited.
Yes.
But the last one is 609. Page
Yes,
6.
I've seen.
Now, my lord, if your lordship may kindly have a look to me, report that I had handed up, not a report as such, my lord, there are certain documents dated 7th of April 2025. But whatever has been said in the writ petition and the complaints, my lord, I have placed before your lordship. My learned friend has also placed. Now, this your lordship will find, my lord, an analysis, my lord, of the CCTV footage which is available at the police station. My lord has found that, my lord. But I'm told, my lord, on the last day, my lord, this was handed up to the court.
Yes, that is there. I'm just trying to find it out. Is it after the general diary entry?
No, my lord, it's a sort of a a chart.
Chart, I don't think in this matter. In the other matter you have given me, not in this matter.
We are sending it to your lordship's chamber. A condu chamber, Joseph.
Here you have got that report along with that bond and all these things.
No, that is possible in the other matter.
No, this is this matter. This is Shushita Soren matter. Other matter, you have given me the CCTV logger that I have gone through.
Yes.
This matter, the CCTV log is not there, although you have got the all arrest register and the Hajat register over here.
Sir, we have sent it to your lordship's chamber, Miller. It may reach within a minute.
Yes. Then come, sir, you carry on.
Miller, page number 1 is the CCTV log of the writ petitioner number 1, Sushrita Soren. Now, Miller, we have analyzed that she was in the police station for 11 hours, 1 minute total. She was taken to the police station at 10:40 in the morning. Kindly take the second page. The first page is, Miller, the covering letter. The second page, which is numbered at page number 1, at the top, your lordship finds, Miller, CCTV log of Sushrita Soren on 3rd and 4th of March. It is 3/3/2025. Time 10:40. Incident: Sushrita Soren entered police station compound. On the right hand side, Miller, the remarks is, initially upon entering the police station, she has been kept in the IO's room with other DSO members, being accompanied with ASI Munki Kisku, plus being accompanied.
Just 1 minute. All these 4 petitioners were arrested from the same place.
Same place.
Same place.
Same
so
place.
if that is so, Mr. Dotto, your memo of arrest is of 10:05 hours.
Yes.
Now
this 10:40 that your lordship finds, Miller, possibly in the other report, Miller, it has been said that the CCTV timing is somewhat different from the actual real time.
That's of 24 minutes. Yes.
Yes. Now 10:40, she came to over here. And on the right-hand side column, your lordship finds, initially upon entering the PS, she has been kept in the IO room with other so-and-so, accompanied by so-and-so, plus so-and-so. They were checked thoroughly by so-and-so, maintaining decency and female privacy. Now, from then at 11:17 hours, she was taken to the lockup. So, after entering to the police station, she was taken to the lockup after 37 minutes. Then at 1 hour, she went to the outside the lockup, to washroom outside the lockup. One thing, my lord, the hashed portion under the column incident are the areas which are not covered by the CCTV cameras. Then 13 hours she goes to the washroom. 13:03 she returns to the lockup. 13:55 she left PS lockup and went to the OC's room. Then it is very important where she met with SUCI leader Bhavani Chakraborty. So she was not in the OC's room alone. Now OC's room is not covered by CCTV. Then 14:03 hours she returned to the lockup. Then 14:19 hours she went to washroom. 14:22 hours she returned to PS lockup. 14:30 she was given food. 14:42 she finished her lunch, except the washroom portion and the OC's chamber. Otherwise she is under CCTV coverage. Then 14:44 she and Tanushree Bej accompanied with so and so went to washroom from lockup. Then 14:47 she returned to lockup. 16:34 she went to washroom outside the lockup for changing her dress provided by police, and she also took bath. Then 14:46 returned to lockup. 17:40 found sleeping. 18:40 gossiping. 19:05 snacks given. 17:15 completed snacks. 17:20 found gossiping. 19:27 found sleeping. 20:32 gossiping. 20:52 again, Millard, she is outside CCTV coverage. She left PS lockup accompanied by so and went to washroom. 20:55 returned to lockup. 21:17 gossiping. 21:29 sleeping. 21:52 dinner. 23:20 sleeping. Then 23:24, where again Millard outside CCTV coverage. I read this portion. She requested Munki Kisku, who was standing outside the PS lockup, that she needs to talk to her. Then we are on the right-hand side column. On her request, Sushrita was taken in a room outside CCTV, where she asked Munki Kisku regarding their release from PS. LC Sushmita Hemrem also remained present at the room. Then again she returns to the lockup at 23:28. 23:32 she further requested to bring her outside the PS lockup. On the right hand side column, she came outside lockup accompanied with a LSI so and taken in a room outside CCTV, where she again inquired with Munki Kisku for their release from PS. Later she went to washroom. Then 23:35 returned to lockup. Then 23:59 found sleeping. 00:20 hours gossiping. 00:40 sleeping. 1:20 sleeping. 1:22 she left PS lockup for bail bond and was seen near duty officer's table. Then 1:41 she, along with other 3 DSO members, left PS after completion of all formalities. Now, Millard, I have personally, Millard, checked up. She was in the police station for 11 hours, 1 minute. Out of which she was outside CCTV coverage, which includes, Millard, the washroom, for 86 minutes. Now this 86...
Mr. Dotto, 11 hours, how can it be?
Well, because from 10:40 in the morning...
Accepted.
Till 1:41.
So that's more than 12 hours automatically.
Oh, I'm sorry, I've 10, 14 hours. Sorry. We have 14 hours, 1 minute. Sorry. 14 hours, 1 minute. Now, out of 14 hours, 1 minute, 86 minutes, Millard, she was outside CCTV coverage, of which, Millard, 24 minutes she was in washroom, 37 minutes, Millard, initially for checking and all that, 8 minutes in the OC's room, and in the OC's room, she was with that Bhavani Chakraborty, their leader. 13 minutes she was in another room and 4 minutes in some other rooms. Therefore, if your lordship deducts 24 minutes from in washroom from 86 minutes, it comes to 62 minutes. So about one hour, 2 minutes, she was outside CCTV footage or coverage minus the washroom time. It would be unbelievable that within 8 minutes, whether or not Bhavani Chakraborty was there in the OC's room, whatever has been told, whatever has been explained, whatever has been pleaded, that could have happened. Then, Milord, paragraph page 3 onwards, Milord, we have again, Milord, assessed, Milord, the time. It is almost the same, a few minutes here and there. Milord, the next is Bornali. Right? Bornali. Now, Milord, next is Bornali Nayak. Milord, she entered at 10:39 and left at 1:42. So 2 minutes more she was in the police station, of which she was in the washroom for 16 minutes and with Bhavani for 14 minutes and the other IOs and all that for 20 minutes. Milord, Bornali at 14:08 hours went to OC's room for 14 minutes where Bhavani Chakraborty was present. Then if your lordship may kindly take me to page number 5, which is Ranusri. 14:03 hours, she went to the OC's room to meet Bhavani Chakraborty, SUCI leader. Then Tanushree Bej, Milord, she went to the OC's room at 13:51 hours and came out at 13:55 hours. 4 minutes. Milord, we have these coverage. Milord, if your lordship requires, Milord, we can produce before your lordships for your lordship's perusal. But I have the evidence with me. I can produce it. I can bring it on record by way of an affidavit if your lordship desires. Now, if my camera log speaks correctly, kindly take me at paragraph 9 onwards, what is said. And I'm not so, I'm sorry, not 9. Yes. Para 11. Paragraph 11 at page 8. 11, 12, 15, 14, 15, 18, 19, 22, 23, 24, 25, And at paragraph 31, they accept that Bhavani Chakraborty had come to the police station. 31, 32, Bhavani Chakraborty's presence, my lord, are accepted by them. But this is, my lord, really unthinkable that police, my lord, who discharge duties regularly were cater to these kinds of protests, prevent this kind of protests, carry on, my lord, these kinds of preventive detention, suddenly will go and beat up, my lord, 4 or 5 persons. This is not something new that the police has done on that day. Police tackling law and order, my lord, is not expected. And the way, my lord, things have been put before your lordship in this petition, where it is very, very rare and unacceptable. I'll use this expression unacceptable, merely, my lord, on the basis of pleadings that these kinds of things happen when nowadays, my lord, the police stations are covered through CCTV cameras. I accept that there is no full coverage. That is, my lord, another problem which we can tackle elsewhere. But, my lord, to the extent the coverage is there, and to the extent the petitioners were outside the CCTV coverage, my lord, during this short tenure when one of their leaders are present in the police station, my lord, these things could have happened. And that person, I can understand these people, they were in the police lockup, they were hit, beaten up, my lord, burnt, whatever has happened. Nothing had happened to that person who could contemporaneously either lodge a complaint over there, or sent an email through his mobile phone, or even sent an SMS, WhatsApp to someone, at least to their acquaintance, not to the police, saying that I'm in the police station. Lord, if something happens to me, or if something happens in my presence, well, it is very unnatural that I will not contemporaneously communicate with anybody, because I went there in the police station as a leader, and I must have been sent. It's my presumption that I must have been sent by that political party, or I was a representative of that political party, or I was a political friend of those persons. Now, first of all, my lord, it cannot be accepted that within 8 minutes, when she was in the OC Zoom, this much of torture has been meted out. Beaten up with the belt, standing up on the leg, hot melted wax, my lord, poured on the hand, caning done. Where someone was pulled by hair and, my lord, hanged. But I respectfully submit, but this is an unbelievable story. These disputed questions were, in my very respectful submission, cannot be gone into in the writ petition. Fortunately, my lord, we have the CCTV coverage. Otherwise, I would have been completely defenseless. And, my lord, I respectfully submit, my lord, unless, my lord, in this background, the petitioners prove their case to the hilt, where I repeat, to the hilt. When, my lord, the allegations are against the, my lord, law enforcing agency, my lord, it has to be proved to the hilt. Otherwise, my lord, they should be saddled with, my lord, exemplary cost, my lord, for abuse of the process. My lord, feigning these kinds of assaults and tortures, my lord, one cannot play fast and loose with the court, and, my lord, spoil the court's judicial time, and, my lord, seek the attention of the court, my lord. And kindly see, my lord, what are the prayers? FIR against the police, disciplinary action against the police on the mere saying. I don't think that is the law. But on the last occasion, when my lord was pleased to, my lord, observe that these police officers are in the status of an accused. But I bow down to your lordship's observation that please consider that when in this backdrop, my lord, whether there is an iota of, my lord, disbelief in regard to, my lord, the so-called activities of the police authorities. But I would respectfully submit, my lord, this calls for an affidavit. I will place those on record for your lordship's consideration. But I can even, my lord, concede to this extent, taking complete responsibility, any forensic report your lordship wants in regard to the CCTV footage, coverage, etc., your lordship would kindly pass that order. But, my lord, I reserve my right to pray for exemplary costs. But if, my lord, my learned friend's client cannot prove their case, kindly reserve this right for me. These are my submissions, man. But I am not distinguishing the judgments which my learned friend have cited, but unless, my lord, they can prove their case by mere allegations and pleadings, my lord, these kinds of cases are not. There is no supporting evidence at all. But these are my submissions.
We shall add only a few lines. Number one, though the copy of the CCTV log that was not served upon us, but still, as we noted down, we found at least 86 minutes. She was at least petition number one, Shuksita Shuren, she was out of CCTV coverage. Question arises why? Paramjit Singh Saini doesn't allow them to put a single minute apart from going to washroom be out of CCTV coverage, including the room of the OC. Why? I am asking myself why the room of the officer in charge is not covered with CCTV for a single minute. Why she will be out of the CCTV coverage? Number one. Number two, probably they do not have any training and they do not know why and how Lathi can be charged. I am not saying anything about Lathi. Lathi can be charged, though this is our specific allegation that when those girls were fell down on the floor, they were kicked. My lord, when they were arrested, was stated on earlier occasion by the learned senior advocate that they were there was preventive detention. Question arises why preventive detention was there. Any case was started. We do not know what are the charges against us. Why 4 girls were taken in front of the college? They did not even enter into the college. What was the necessity of arresting us? Learned AG was silent. Thereafter, our case was 8 people. They were showing peaceful demonstration. My lord, there are police acts. I am not going your lordship into that. Assembly has to be declared illegal. Thereafter, some rules are there when and how Lathi can be charged. Whether anything was done, whether at least verbally declared that this assembly was illegal, nothing was done. 8 girls, 4 girls were taken into the custody. They were kept for the whole night inside the custody. I am asking myself, is it the law? National Human Rights Commission recommendations supports this. Now they have come to cover up the entire story, though they are unable to cover up at least 86 minutes. Why? Petitioner number 1 was out of CCTV coverage. How dare this officer in charge? He did not put a CCTV camera in his room. Still, learned advocate general is saying 8 minutes she was in this room, 8 minutes she was in that room where CCTV was not there. Question arises why inside and outside at least an inch, inside and outside of the police station at least 1 inch was outside the CCTV coverage apart from washroom. Learned advocate general is saying they could have informed other persons. I am asking myself, phone was allowed inside the lockup? If I admit this for the time being, yes, they were having smartphone or any kind of phone.
phone was allowed on that date inside the lockup. Police allow phones inside the lockup. They will inform other persons. My lord, we are praying for some directions to know when and how police can charge lathi, how police can take weapon on their hands, when and how. My lord, a direction is required in these days. Your lordship is aware of all the facts which are going on in entire West Bengal. A direction is required, my lord, for today. This has been admitted that no CCTV, there was no full coverage of the CCTV. Thereafter, my lord, Learned senior friend is saying, we have to prove the fact, our fact. We were taken inside the lockup, we were beaten up mercilessly, and we shall prove that. How can we prove? Even there were the marks on our body. Within these days, that has also gone away. How can we prove? We went to Medinipur Medical College. There, they acted as per the direction of police. We came at Calcutta. Calcutta Medical College also stated something happened. They did not.
Mr. Chatterjee, you tell me one thing. We are not considering whole of the petition. What we are considering, I mean, the whole of the prayers. What we are considering at this stage is regarding the interim prayers. Now, what are you agitating now is, if I am correct, that atrocity inside the police lockup are from the initiation of the incidents happening from the college gate.
From the starting of the college gate, because we were beaten while we fell down on the floor. They kicked us. They used belt. My lord,
that is
outside. That is
outside or inside the police station.
Outside of the police station. But my lord, we are praying for direction. Why and how police can use lathi?
That is a separate issue, sir. You tell me.
I bow down, my lord. But my lord,
what are you wanting now?
I'm coming, my lord. I'm coming, my lord.
Now I'm asking again, sir. What are you wanting? One,
I'm coming, my lord.
In respect of actions inside the police lockup, or whatever incidents have been complained of from the time they were picked up or detained by the police.
I not both, because my lord, learned advocate general stated that there was preventive detention. Question arises, how and why preventive detention was required? What we did and what are the charges? My lord, we were allowed on bail, but we have the right to know what are the charges against us. Whether we have destroyed any government property, whether we have looted anything, vandalized anything, what we did, number one. Number two, well, no weapon was recovered from us. This is not their case that some kind of weapon was recovered from our possession. Why we were arrested? Poor girls, they were kept till midnight in the police station. Why? I'm asking myself, my lord. And this is the queries from the petitioners. Next, my lord, we have prayed for disciplinary proceeding. And my lord, if your lordship process any interim order, whatever falls from your lordship, then my lord, these officers in charge and other officers who were there inside the police custody, police station on that day, they have to keep outside of this police station. Otherwise, my lord, no impartial investigation is possible if that officer in charge is sitting on her chair. My lord, kindly comes to our prayer.
I've seen. Now see, disciplinary proceedings at this stage without exchange of evidence is not possible.
My lord, our prayer was, my lord, whatever falls from your lordship, we shall
No,
wait.
Sir, I have got to understand the scope.
Yes.
You can pray many things and you are entitled to pray many things. Now you tell me one thing. Over here, again I'm repeating. You want this incident or whatever to be covered from the time you were picked up by the police authorities took in a police van to the police station. And thereafter, whole of the day or night, up to the time you were there.
Not when we were picked up by police. When police arrived there without any provocation. When police arrived there, jumped upon us. From that period of time, we want your lordship's intervention. Whether it was required, whether presence of 60 police persons were required, whether order of lathi charge was given, what if any order of lathi charge was given, where is that? Your lordship knows everything, my lord. There must be the order of lathi charge. There were only 8 girls. Why the order of lathi charge was given? If order of lathi charge was given without having the.
Show me the pleading. Show me the pleading regarding lathi charge.
Yes, my lord.
Yes.
From the very beginning.
Yes.
Page 8, paragraph 8. Page 7, last line of paragraph 8. Sorry, it starts from paragraph 8. Thereafter, paragraph 10. Thereafter, paragraph 11. Paragraph 11. Without any provocation and without giving any opportunity to the petitioners to even speak to the police officers, the police personnel came down heavily upon the petitioners and the 4 other protesters and started assaulting them with lathis, fists and blows and puts. And owing to the severity of the assault, the petitioner suffered grave injuries and the petitioner named Ranusri became unconscious. Thereafter, the petitioners and the other 4 protesters were then forced into 2 separate prison vans which headed towards Kotwali police station. Since the petitioner Ranusri Bej was still lying unconscious inside the prison van and petitioners begged the escorting officers of providing water to her and to take her to the nearest medical facility. But no police personnel paid any heed to the condition of Ranusri Bej. Here, I'm pausing for a moment. Again, violation of Bharatiya Nagorik Suraksha Samhita. At least we had to get the consultation of medical officers. That was not allowed. Violation of law, my lord. Violation of law. They do not know the law. That's why we are before your lordship. We need one direction from your lordship, my lord. Thereafter, finally comes to paragraph 13. At 11 a.m. in the morning, we were taken to police custody. Thereafter, this is the admitted fact. We were released from 2:20 a.m. at midnight. Why? I am asking myself. Why? What was the necessity of keeping us behind the bars till midnight? Is it law? Is it permissible? No case is there. There is no specific case, no specific allegation. Thereafter, paragraph 14, at the women police station, the petitioners were thrown into a room which was not the lockup, and the petitioners later realized that there was no CCTV cameras installed in the said room. This is also violation, my lord. This cannot be. In these days, this cannot be. Paramjit Singh Saini specifically says this. Violation of law. OC's room is not under CCTV coverage. This is surprising, my lord. Thereafter, paragraph 15. I have thoroughly discussed how they used belt. My lord, police, they do not have unfettered power, my lord. They cannot take lathi on their own. All right. If I admit this for the time being, that as my learned senior friend stated, something more is there, be that may, my lord. Police cannot take lathi on their own, on their hand. Is there any direction from superior officers? Where is that? I am asking myself. Where is that? We are saying they used belt. We are saying that hot melted wax was used. Let them prove that that was not used. Where is the CCTV footage? Where is the CCTV footage? We are saying that we were taken to OC's room. Can they deny that we were not taken to the OC's room? They are saying, yes, we were taken to the OC's room. But what happened inside OC's room? Regarding that, they are silent. Again, they are saying that one Monica Pisku, a lady sub-inspector, we were taken to her room. That was also not covered under CCTV footage. Why? Marar ghar. That was being used as Marar ghar. Even thereafter, my lord, I learned stated that they took us for bathing. Where we have also stated that to cover up the beating, the marks of injury marks on our body, they forced us to take our bath. This is our case, and that has been admitted. They gave us alternative wearing apparels. Why? Where are our wearing apparels? Learned Advocate General said that dresses were provided to us. Question arises, why? Because our dresses were completely torn. Well, we have annexed few photographs having injury marks on our body. When they were releasing us, they also did not allow to go to the medical expert. That was not allowed. That is also violation of Bharatiya Nagarik Suraksha Samhita. Again, our prayer is this investigation should not be done by police officers, because they shall always try to cover up their own misdeeds. And my lords, few citations. Tirajul Islam Gharami, that has gone back to single bench. And state advocates, they are not appearing over there. They are regularly taking time. Subasing, my lord, paragraph 15, completely contradicts. Be that as it may, my lord, regarding the citations upon which Learned Advocate General has relied, we have given written notes.
You have given written notes?
Here, my lord, we have another prayer. SC/ST Act, my lord, that has not been incorporated in this. No case has been started. A case immediately should have been started incorporating SC/ST Act.
No, SC/ST Act would have been started, you say, but the specific accusations which you have made is against a lady police officer who herself, I believe, belongs to the same caste.
As I understood, we have the list also, my lord. Mahato is not, my lord, Mahato does not fall within the list of, my lord, SC/STs. As I understand,
it doesn't fall. I don't know.
Doesn't fall, as I have instructed, my lord.
Where is your written notes of argument?
We have submitted, we have distinguished everything, my lord.
Okay.
My lord, this central list, my lord, this central list I can submit before your lordships also.
List of judgments I have. But written notes তো ওরা দিয়েছে, গভর্নমেন্টের তরফ থেকে দিয়েছে। এই তো written notes আছে, এইটা তো ওদের তো।
Distinguished each and every citation.
আরে এই জাজমেন্ট গুলো তো অ্যাডভোকেট জেনারেল জয়ন্ত দাদা এটা কোথায় রেখেছো? কি করে দেবে? এটা তো অ্যাডভোকেট জেনারেল দিয়েছে, জাজমেন্ট মিলছে না তো। আমি দেখেছি। You got a copy of the written notes of arguments with you?
Tomorrow we shall
No, have you filed that?
Yes.
Huh?
Yes.
এটা তো অ্যাডভোকেট জেনারেল রিটেন নোটস of
probably the written notes of arguments which is before your lordships, probably that has submitted by us.
No, the list of judgment shows that it's advocate generals.
No, we do not have. We have given a separate list of judgments.
No, that's a list of judgments is there.
My lord, I have not, my lord, supplied or submitted any list of judgments.
So then this is the distinguishing the judgments only of the Advocate General.
We have not given any list of judgments. Mr. Chatterjee has given a list of judgments.
That is ours, my lord. That is ours.
This is yours. You have only distinguished the judgments over here.
Along with the judgments which we have relied.
So that is only a list.
No, my lord. All the copy of the judgments we have submitted before your lordships. All the copies.
The judgments copy along with the list of the judgments are there. And this is differentiating the judgments relied upon by the Advocate General basically.
No, that is submitted by us.
By you.
জজ সাহেব কথাটা শুনে উত্তর দাও। জজ সাহেব জিজ্ঞেস করছে তুমি ওই লিস্টে আমার জাজমেন্ট গুলো সেটা বল, এটাই জিজ্ঞেস করছি।
Because your judgments are not over here. Your judgment list is there, but your contention relating to the judgments which you have relied upon, that is not dealt with over here.
And what we did, we have given list of judgments. Number 1, we have supplied all the judgments before your lordship. Number 2, number 3, only few pages wherein we have distinguished the judgment.
That is what I wanted to know. Then it is there.
Yes, grateful, my lord.
কবে দেবো এবার? আজকে এখন বাজে 5টা। কাউকে তো পাওয়া যাবে না 4 দিন। একুশ তারিখে দিই, তার আগে হবে। তুই তো টাইম চাই আমার, না হলে কি করে হবে? একটা তো অর্ডার ফর অর্ডার্সে রাখতে হবে, একটা কিছু অর্ডার দেবো তো ইন্টারিম অর্ডারের জন্য। 21st I am not possible before that.
Very well.
Because only 2 working days.
Very well. Now, can I utter a half sentence?
Yes, please. So many words.
Half sentence is Bhavani Chakraborty's presence not disputed in his reply argument. That's all. Nothing more.
Acha. Petition, Learned Advocate General, as well as the petitioner conclude the arguments so far as the issue relating to interim prayers are concerned. এদের তো দেওয়া আছে তো না? আচ্ছা, ঠিক আছে। List the writ petition under the heading for orders on 21st of April 2025. Only for orders on that date, no submissions.
The copy which your lordship have received, that is that of 11 pages. 11 pages, my lord.
Yes,
11,
yes.
Then my lord, those were ours.
ঠিক আছে। Only the order I will pass on that date. Nothing. এটা ওই পিটিশনারে দিয়ে দিন। হয়ে গেছে, ওদের ডেকে পাঠাও।
May I take your lordship's leave, my lord?
Without joining any of the Hanuman Jayanti programs or what?
Hanuman Jayanti. Kindly take it up tomorrow, my lord. I am in real difficulty, my lord.
6 petitions are there tomorrow. Difficulty is 3:30. Court is off.
Kindly take it up in the first half, my lord.
First half, no other matter. Mr. Dotto, no other matters can be taken up for these matters. First half tomorrow.
But I am really in difficulty, my lord.
My lord, it is, my lord, with the Hanuman Jayanti, my lord, the arrangements have to be, like, my lord, ours is, my lord, is on day after tomorrow early morning, 5 o'clock. And my lord, it's on Red Road, which our prayer was. So, my lord, I'm asking if it could be taken up.
Huh?
If it could be taken up, my lord, if these matters could be taken up.
Supplementary list has been published, my lord. In that, my lord, in North Kolkata from College Street, wherein the leader of opposition is going to be present. Now, my lord, certain arrangements are to be made. If your lordships kindly takes it up tomorrow.
Who are appearing in these matters? Who are appearing in these matters?
Advocate General in my matter. That is like all
আরে 4:30 বেজে গেছে কি করে মামলা করতে বলিস জজ সাহেব এন্টারটেইন করে বলে 4:30 5টা এসে মামলা করতে চাইবে আর্জেন্সি আছে বলে 5:30 4:30 পরে হয় নাকি জজ সাহেব এন্টারটেইন করে বলে তোমরা এটা বলো এটা হয় নাকি আমাদের কাজ নেই তো 4:30 পরে তোমরা কি করে প্রেয়ার করো প্রেয়ারটা
takes up all the matters, my lord. 10:30 tomorrow.
No, Mr. Dotto is appearing in all the matters.
Yes, we are preparing all the matters.
Yes.
In all matters.
is appearing. Matters 390 and 391.
Which one?
Please take it up tomorrow, man. I don't think that this will take much time.
Fighting goes on, sir. Calcutta emotion কিছু হবে না এইসব মামলা নিতে গেলে
It would not take much time because
we have other work, sir. We have other work. After
10:30 tomorrow, kindly, my lord.
Your lordship can understand that our problem also. Lord, we have approached before your lordship's court for getting permission. Just one day before, if your lordships grant us permission, it is very difficult to arrange that the program also for us.
But that does not mean that
we have given them intimation on 1st of April. Today we are on 10th of April.
Now the 7th April.
No, all of একটু দেখি কিছু করা যায় kiনা. All of your applications have been rejected.
My application has been rejected, my lord.
So far as my lord so far as Red Road is concerned, 7th April application and 7th April repetition of
very good. Any application has been allowed by the state.
Not saying that, my lord, you cannot do
one is yours, sir. Any application has been allowed by state out of the 6. আরে বাবা আমি জিজ্ঞেস করছি তো any of the application state has allowed.
Item number 390 and 391, which is pertaining to Basroni PS. But we have no difficulty if the program is held. But only, my lord, 2 things. Wherever they want to put their pandal and paraphernalia, they should take permission from the relevant authority. If it is on the road, from the KMC. If it is on private place, from the private person. And they should not cause any inconvenience to the public. These are the only 2 things.
Just 1 minute, which are the matter? 390.
The only thing, my lord, is that we are not being given the time to either allow or reject. Application is being made. They are immediately coming for your lordship, saying that there is an inaction.
আর কি বলবো আমি আর কি
Item number 390, 391, my lord. I am led by learned.
Just 390, 391, it's all right then. Then what is left out now? দুটো allow হবে মোটামুটি রেখে দিন আর বাকি contest হবে কি হবে?
So far 390 and 391, so far corporation is concerned, they are not handed over with any permission from the state. Until and unless permission is given to us from the state, we cannot invoke our provision under section 354 and 356 to ascertain the ascertain and
wait Mr. Bondwa, what are the other 4 matters? দেখি লিস্টটা দিন না আমার একটা
kindly take up 389. My matter.
The street block is of the state.
This is on Red Road, my lord.
এটা না এটা সাপ্লিমেন্টারিটা কোনটা সাপ্লিমেন্টারি এই লিস্ট তো দরকার লাগবে না একটা সাপ্লিমেন্টারি 391 কি বলছে is item number what?
Item number 390 and 391. Item number.
One is concerned with that earlier order must be ordered justified. The condition was imposed below that
390 এইগুলো.
But these are programs being held for 4-5 years, my lord. We have no difficulty.
Acha. 389 who is appearing?
I am appearing. 380.
389.
But kindly, my lord, the C, when I have intimation has been given by me, that is on 1st of April 2025. Your lordship will get that in page 23 and 24.
Just 1 minute. Mr. Bagji's matter is which matter?
My lord, my matter is supplementary list, my lord. The only matter as appearing in the supplementary list.
Acha. This is from where to where?
This is scheduled to be held from College Street, Bata, from to Hori Ghosh Street, Hanuman Mandir, in the North Kolkata area.
Sunday.
It's on 12th.
Sunday too.
Saturday.
Saturday.
State holiday. But in this program, the leader of opposition is going to be present.
For me, who is appearing in this matter? 12.
I appear led by Advocate General in this matter.
Mr. Shopon Banerjee is appearing led by the Advocate General.
Lord, we have no objection, but the restrictions your lordship kindly put, Lord.
Yes, my lord, kindly record, sir.
Time period?
My lord, from 6 p.m. to 8 p.m. My lord, it needs time to gather the procession.
Permission
the procession will be.
They are sensible, sir. I am forcing state. Some sensible prayers, Mr. Bagji. I am forcing
5
state.
to 8, then my lord, kindly 5 to 8. 5 to 8.
5 to 8, all right, Mr. Banerjee. Other conditions will be there.
Yes. Yeah. 5 to 8 p.m.
But 5 to 8 in the morning.
No, evening.
Lord, all right, Lord, 5 to 8, your lordship can, but Lord, without any, Lord, the sound system. And provocative.
As usual, microphones 5 to 6 will be there. What is your accumulation of persons?
My lord, we in our representation we have stated that as per our information as of now, around 200 to 250 devotees will be there.
The 4-5 microphone DJ will be not there. DJ is not required.
No weapons. No bike, no weapon. Your lordship kindly consider.
Mr. Bagji, what I request, don't give a DJ system. Don't give DJ system. Doesn't look nice.
And Kolkata Municipal Corporation permission is necessary.
Kindly consider, so far one is concerned.
1 minute, sir. I am dealing with it, sir. 1 minute.
Only certain music system, it's a procession, kindly.
Music you carry on. Don't carry on those DJ system, cheap DJ system. Doesn't look nice in this in religious activities. At least have some test.
My lord. In the representation is not there. I cannot comment on that because I have no instruction with the DJ. As it falls from your lordship, As
religious programs, microphones with whatever bhajans and although you do all those things, I've got nothing to say. Don't introduce all those.
Your lordship kindly,
my lord is then disposing of this item number 1 in the
I just 1 minute, Mr. Banerjee.
What your lordship has done, in Lord Ram Navami.
করে দিচ্ছি 1 মিনিট আমি শেষ করিনি এখন মিস্টার ব্যানার্জি বি देयर এইটা হবে
I'm led by Advocate General in this matter.
I'm not disposing it of one by the ones which can be disposed of now. I'm just reducing the number of matters. One over here 390 391 এগুলো হবে আচ্ছা
the corporation has the problem. We could not supply any utility services because we didn't get any application in time.
Okay, 1 minute, I'm coming. 392, who is appearing?
392. No, 390.
Chaudhary had mentioned at 2 o'clock before your lordship that he has.
Oh, that's an arrest matter.
Yes, arrest matter.
So this has got nothing to do with this Hanuman Jayanti program.
Tomorrow that can be mentioned tomorrow morning at type 2.
এটা গেল আর তাহলে রইল হচ্ছে 1 2 so there are 4 matters 4টে মামলা তো এত দিচ্ছে 4 Hanuman Jayanti matters, sir.
Yes, 3 matters and Red Road matters will be taken up at 10:30 tomorrow.
Red Road 1 matter.
1 matter. Kindly takes up the matter at 10:30.
All right.
We have some
all right tomorrow 390 391 and item number 1 I'm passing the orders then. Learned lawyers according to Mr. Mojumdar come at 10:30. I'm trying to reduce the number so that things can be done on. So where there is a consensus, I'm passing orders. Where there will be contest,
we have some submissions over the Red Road. Lordship kindly consider this.
We are having from.
Then your lordship kindly pass the order. There are other places. But why
Red Road? Wait, Mr. Banerjee, I have said that will be taken up at 10:30. Why are you unnecessarily creating a tension? I've said wherever there is a consensus now, I'm passing the orders.
I'm sorry,
Wherever
Your
there is a contest, tomorrow morning I will take up the order.
Malad, the conditions as in Mr. Shopon Banerjee's matter may be incorporated in 390 and 391 as well.
You wait one by one, sir.
Fine.
Just order card ঘাড়ে পড়ে যাবে তারপর পাবে না।
Supplemental list item number 1 টা দিচ্ছেন।
ওই এটা কোথায় বাঁশবেড়িয়া
Supplemental item number 1 কোনটা?
এইখান থেকে নিয়ে এখানে গলমালটা এখানে হচ্ছে 390 আর 391
390 টা মালাট আমার কাছে আছে হাতের ধরে
8295 Mr. Bandyopadhyay, you are appearing.
My lord.
Who is the advocate for the petitioner 8295 WPA? How many members? How many participants? How many participants, sir?
Exactly what each petitioner is there, my lord, but the local people will be there, my lord.
You have got to say the number of. This is what, organizing a program or a procession?
Lord, we have in this application, there is no position, my lord. But organizing the program, my lord, as stated in the name of the petition, my lord, as stated, specifically stated.
Malad, there is a existing Shiv Mandir. They want to have the separate Hanuman Jayanti puja in the surrounding of the Shiv Mandir. That is why I mentioned that if they are in a plan to encroach the road, appropriate permission, they may approach the KMC. Malad, that is my one of the conditions, and the other condition, not to cause any disturbance to the people in the locality and the passerbys. I have no further conditions, Malad. They may, it's a mandir, they may conduct a puja, that is up to them, how they want to do it.
You are for the KMC, Mr. Vishash.
Malad, we didn't get any permission from the state authority, and after getting the permission from the state authority, Malad, we will convey an inspection and we will invoke 354 and 356 of KMC Act for causing road blockage. If they don't cause any road blockage, Malad, then we don't have anything to say, Malad. And if they want to make any pandal or something like that on that road or in the corporation area, Malad, we will have to assess. We will have to levy tax upon them, Malad. These are the parts, Malad, which we need to do.
This is the Tollygunj area.
We don't have anything to say.
Achha. So they will take regular permissions thereafter, whatever they can be done.
My no objection can be recorded today. KMC will act tomorrow, Malad, whatever, whichever.
No, whatever, all disposals are subject to all permissions being granted by the authorities concerned. They consider. Why keep these matters? These are worship only. No procession, nothing like that.
No, 391 is procession.
390 is procession, Lord. I'm coming there.
I'm coming to that. 390
so take their undertaking that they will not use the corporation property or road or something like that.
They will take permission. They will conduct the worshipping and the they have said in paragraph 2 of the petition, adjacent to the Shiv Mandir over here. So whatever they do, they will do according to the statutory permissions being granted. Court is not there to legalize any illegality, sir. Chalo.
390.
They have 390. Petitioner has approached the court as they did not receive any response to the representations and to the municipal commissioner. প্রথমে দিন এটা দিন কাকে দিয়েছে to the joint commissioner of police Kolkata police on March 26, 2025. Acha, municipal commissioner Kolkata municipal on April 7, 2025. And the Director General of West Bengal Fire and Emergency Services on April 7, 2025. Full stop. The petitioner intends to worship Lord Hanuman on 11/4/2025 and 12/4/2025 at Satyendra Polli Shiv Mandir, Brahmapur, Goria, ward number
Worship
111.
is only on 12th April, my lord. Worship is only 12th April. Pandal making is 11th April. Worshipping is only 12th April.
তাহলে 12th April করে দিন এটা কি আচ্ছা ওয়ার্ড নাম্বার 111 গড়িয়া পিএস বাঁশজনি ক্যালকাটা 84 ফুল স্টপ আচ্ছা petitioner would ensure that all permissions are taken from the respective authorities for or the worship to be conducted at the temporary structure of the pandal which the petitioner proposes is to construct adjacent to the Shiv Mandir. Full stop. In case the permission of the respective authority is available, the administration and or the police authority would ensure that no obstruction is created in the worship. You have an evening program also or what?
Lord, it is from 11 a.m. Followed by 6 to Barjangbali. 6 p.m. up to 6 p.m. Lord.
Nana, whatever you do worship, I have got nothing. You have any program, other program?
Cultural program, Lord. Just culture.
সেটা বলো
Prasad distribution.
আর কি বলছি
ensure that no obstruction is created in the worship.
Worship. Full stop. Petitioner also has prayed for or a cultural program. Full stop. In case any cultural program is done, the same should be completed by 10 p.m. on 12/4/2025. The petitioner and or the other participants would ensure that the decibel limit permitted by the West Bengal Pollution Control Board is maintained so far as the sound limits, decibel/sound limits are concerned. Full stop. Petitioner would also ensure that there is no inconvenience caused to the public at large and is it a what pathway road? Mandir is where at the main road.
Pathway road.
A petitioner would ensure that for
the traffic disturbance will be there, my lord. No traffic disturbance will be there, my lord. If the program conductor, the pathway, it's not a main road.
There is no inconvenience caused to the public at large
and their movement and their to and fro movement. What more conditions?
Well, Lord, one was and the other was all necessary permissions, and one is no disturbance to the residents of the local and the passerbys.
That I have given through and fro movement of the people.
Since we are recorded by there will be no road blockage. Yes, there's no difficulties there as submitted by Mr. Banerjee. Full permission is there, as I have understood. So far as Mr.
Vishas
is concerned, that we need to take formal permission from the corporation, and it will be start on and from tomorrow. In the meantime, permission not
go on with their program.
That program will be
road blockage is necessary. We will have to invoke 354, 356.
I don't know, Milord. Earlier occasion permission is given, Milord. Program conducted, no difficulty was there on my part.
So you see, organize that. The earlier years you have conducted.
Yes, I got permission.
ওটা দেখিয়ে কালকে চলে যাবে
Since on the early
no permission was there. Sorry, Milord. No permission was there earlier occasion. Sorry, Milord.
But you are conducting the puja.
Yes, Milord. Yes.
Since the petitioner has been organizing the puja for the last few years, petitioner would adhere to all the norms, and to that extent would seek cooperation from the local police station. Full stop. It is further reiterated that none of the local residents should feel inconvenience for the program and or any crowd accumulating because of the festival and worship being conducted at the said local referred to above. চলো আর কিছু দেওয়া যাবে with the aforesaid observations এটা হলো তাও কাল সকাল WPA 8295 of 2025 is disposed of.
Previous year, no permission was given.
Arey Baba, you have been conducting, you know, cooperate. Ask the OC Bazoni PS, they will help you. Next one also you know.
In this matter, you also kindly page 21. Let us earlier in the year minute and this was filed minute, order was passed by Honorable Justice Joyce minute. That page 23.
I am not objecting. Kindly take their application.
That condition that was imposed in same place, same location, minute. That condition was indicated in the order. Kindly see. Start from
earlier you said earlier year you did for 6, 10, 7. This you are wanting 3 days, 10th to 13th.
Yes.
10th তো আজকে আরম্ভ হয়ে গেছে তো আর পারমিশন দেবো কেন?
From Kumar Monitor today is already finished. Definitely, Mirror.
See case 24. Because in the earlier occasion, they obtained the permission.
So permission they will seek, sir. Without permission, don't allow anybody. কি বললাম? বলি যে একই অর্ডার করুন, এটাও ইন্ডিভিজুয়াল তো।
Order in terms of court's order, Mirror, permission card.
Yes, individual is there.
এটা করে দিন ওই একই পারমিশন সিক ফর করেছিল ডেটটা বলে দিই ওই জয়েন্ট কমিশন হয় 1st of March 2025 ওখান থেকে নিয়ে নেবেন একই অর্ডার টাইপ করবেন হ্যাঁ নো রেসপন্স আচ্ছা প্যারাগ্রাফ 2 থেকে ডিটেলসটা নিয়ে নেবেন ডেট গুলো এটা 11 to 13th করে দিন এপ্রিল 2025 ডেসক্রিপশনটা এখান থেকে প্যারাগ্রাফ 2 থেকে পুরো নিয়ে নেবেন আগে যেটা বলেছি সে প্যারাগ্রাফ 2 থেকে নিয়ে নেবেন হ্যাঁ আর সব পারমিশন গুলো নিয়ে নেবে যা ছিল একই হ্যাঁ চলো 8298 of 2025 is disposed of চলো হ্যাঁ সাপ্লিমেন্টারি দাদা ওই আছে
Supplementary 1.
Supplementary.
Item number 1.
আরেকজন লাগবে আমার এখানে
With the desired route blood has been paid for, but Lord kindly restrict Lord, your I have already submitted to your lordship.
Mr. Bagji, yours is from College Square to Horigo Street.
It's near College Street, Bata, Hanuman Mandir to Horigo Street, Hanuman Mandir.
Lord, we have no objection. Lord, the desired route, Lord, we have no objection.
You are an organization or an individual, sir?
No, it's an organization, unregistered organization. Hanuman Janmotsav Udjapon Samiti.
But you are individually approaching before
Yes.
Achha, you sought for permission when? Which page?
Malat?
Sought for permission.
Yes, kindly see page number 14 on 30th March.
And 8th April. Achha.
On 8th April, a reminder letter was given.
Achha. Petitioner has approached this court as he did not receive any response in respect of the informations furnished with the Office of the Commissioner of Police Kolkata and the Joint Commissioner with the Office of the Commissioner of Police Kolkata.
The officer in charges were also served with a copy where from the procession.
On 30th March 2025 and 8th of April 2000. 8th of and 8th of April 2025. Petitioner intends to organize a Shobha Yatra from College Square Hanuman Mandir to Hori Ghosh Street, Hanuman Mandir, with 200 to 250 participants.
But our people will be there around 200 to 250.
You control that, sir. Otherwise, it will be very difficult.
Yes.
With 200 to 250 participants, which will be which will come. You will start from College Square, no?
College Street, Bata. From College Street, Bata, Hanuman Mandir.
College Square, na College Street, Bata, Hanuman Mandir. আচ্ছা, full stop দিয়ে দাও, তারপরে দেখো এটা full stop. The same procession would come in from College Street, Bata, Hanuman Mandir at 5 p.m. and the same as represented by the learned advocate appearing on behalf of the petitioner would conclude at Hori Ghosh Street, Hanuman Mandir at about 8 p.m. Full stop. Petitioner, learned advocate appearing on behalf of the state has raised no objection in respect of the route concerned, but has forwarded certain conditions. Full stop.
No bike, no DJ.
The mic, we said that there will be no DJ, but there will be sound system, music,
No bike.
sound system,
motorcycle, bike.
and there will be dancing.
Soothing songs will be there, Mr. Bandyopadhyay. ওই এটা করে দেবে যে কন্ডিশন গুলো আছে।
Now we have no objection.
হ্যাঁ, কিসে? What is no objection?
The religious sound, no objection.
Religious
But,
sound.
but if there are other languages.
No, DJ, no, I have told him he has agreed to that also.
No DJ, but sound
And no bike, no motorcycle. Lordship kindly.
এক দুটো তো থাকবেই, না হলে কি হবে?
For our volunteers, it will be needed.
আচ্ছা, আমি বলে দিচ্ছি,
Lordship kindly restrict bike.
What's the problem?
250 লোকে 5টায় বেশি নেয়। মাইক্রোফোন 5টা থেকে 6টা দিয়ে দেবে, হ্যাঁ। আচ্ছা, আর ওই গাড়ি একটু লিখে দেবে, ওই ওই 4টে গাড়ি আর 4টে মোটর বাইক দিয়ে দাও, এর বেশি লাগবে।
Kindly, my lord, motorbike, my lord, would kindly increases.
250 লোকের কথা, 4টে গাড়ি দিয়ে দিচ্ছি তো, 4 vehicles I'm allowing.
Yes.
It will be needed. Certain bikes would be needed for the
But
volunteers.
in that event, Lord, we have objection
overseeing the
because
entire
road, your Lordship, no.
প্রবলেম
Calcutta road.
না না, ওই ট্রাম লাইনটা খুব প্রবলেমের, নর্থ ক্যালকাটা, যে পুরোটা ট্রাম লাইনের রাস্তা।
Traffic inconvenience, traffic.
You go there. That's why I've allowed 4 vehicles, sir. Big vehicles you take, no issue. আচ্ছা, আর একটা জিনিস যেটা বলা আছে সেটা হচ্ছে যে if the petitioner intends to use a symbolic weapon, for the procession, the same should be made up of PVC. No metallic weapon should be allowed to be carried at the procession. আচ্ছা, আর ওই 5 microphones বলে দিয়েছো? আচ্ছা, আর no DJ. হ্যাঁ, আর the procession ওই একটা দিয়ে দেবে would
It will not create any inconvenience to the traffic.
The procession would proceed in a manner from one side of the road, so that the plying of the vehicles is not completely stalled. Just go in a manner, it's not completely, it's a slow movement may be there, but should not be দিয়ে ওই ডেটটা দেওয়া হয়নি, ওই 12 উপরে যেটা টাইমটা লিখলে না, ওখানে on 12/4/2025 করবো, আর কিছু নেই তো, ইয়ে হয়ে গেছে।
Disposed of.
With the aforesaid order, WOPA 8396 of 2025 is disposed of. And tomorrow 10:30 tomorrow এটা ফার্স্ট ম্যাটার ডেকে নিতে পারবো। এই সুদীপ রামটা কালকে এটা নিচে লিখে দেবেন, 10:30 লিখে দেবেন। 389 বাকিগুলো তো হয়ে গেল। 392 ওরা কালকে দেখবো, কালকে না 10:30 বলিনি, বাজে কথা বললে হবে নাকি, যেটা বলেছি সেটা বলেছি। 389 tomorrow at 10:30.
392 will mention tomorrow morning.
Bring AD.
I saw Mr. Abhijit Muzumdar is there.
Oriji Chakraborty. So bring him, then I'll pass a direction. They will want affidavits, I'll pass that direction.
Milord, so far as the earlier order passed the Bakchi's matter. But only Milord, your lordship can add one line. But the bike who will use, but with helmet. Your lordship kindly. Without helmet, you can't.
With helmet to body.
Kindly, Milord.
Bike ওখানটা দেবে
Lordship, item 146, my lord. Can it be taken up today or lordship any day at 2 p.m. lordship? Petitioner is not there, de facto is not there. The first specially fixed matter.
I will not take up this matter till next Wednesday. You come up on Monday, 21st, you come.
Lordship.
You
21st 2 p.m. lordship, shall I serve?
That I will see, because how I progress in such a short time, I cannot decide actually.
Lordship.
So many matters are there. Let me complete. Tomorrow also there is a 3:30. Then 16th, 17th, you understand what will happen. Half of the lawyers will not be there.
Lordship. Lordship.
Please come up 21st. I think I'll be able to cope up with everything.
Grateful to us.
দেখে সব কটা দেওয়ার দরকার নেই।